Next date है transfer brief.
Yes, yes.
Transfer brief date में fix है.
It is submitted that the brief has been received recently, and therefore some time is required to prepare. Place this matter on 19th September.
Please, Your Worship, item number 17, I seek for an adjournment.
Item 17
17
of the supplementary list.
Yes.
Duryodhan Bera versus State of Odisha. Akshay Kumar
Yes.
Sahu.
Yes, Your Worship.
Place this matter on 19th September as per.
We are yet to obtain few documents if it can be listed at the end
26th,
of
all right, 26th September.
next.
Anything else?
Well, item 21. And we need to manage it to come next week.
Place this matter next week as per.
Item 26, I appear on behalf of Malansina Ms. Sarangi. May kindly be permitted to withdraw my lords.
Permitted to withdraw.
Deeply appreciated.
Yes.
Supplementary list item number 1 election petition.
My lord, the lordship can have a glance at the notice.
Yes.
Notice was issued,
Someone.
but it could not be served.
You have to take fresh notice. आपको
I
कराएंगे.
am face notice no say permitted to take through special peon. And now the assembly is continuing the notice is at Bhubaneswar.
So you give the address.
What the quarter allotment it may be served through speaker of the assembly.
All right. So how can that order be passed? Unless you.
Special peon cost I will deposit by tomorrow.
Land Council. In view of the office noting that the notice could not be served on the opposite party. The respondent, were they?
My lord.
Respondent.
Sole respondent.
Respondent, as she is presently attending the assembly session at Bhubaneswar.
Right.
An application has been filed for a direction to issue fresh notice to be served through the Speaker of the Assembly in order to avoid unnecessary delay.
Right.
Stop. Considering the submissions and the facts mentioned above, prayer is allowed. Let notice be issued on the sole respondent
Special
by special messenger, the cost of which shall be assessed and deposit be made by tomorrow. Further, such notice shall be served on the sole respondent through the speaker. Short returnable date be fixed. Place this matter on 26th September.
Item number 2 press admission.
My lord, petition file transfer petition for transfer from family court Bhubaneswar to civil judge senior development culture. My lord, petitioner was a teacher and he has a 10-month child, baby child. So every data appearance in Bhubaneswar court very difficult.
All right. Notice. Stay. Date. Date करो. 24th. कल में इतना 24th. कर दो ना. 7th November. Yes.
Item number 3.
My lord, I am appearing in personal matter from Sambalpur VC. I have been number 5 in a suit in the civil judge senior division Borough. My lord, I am aged of 74. I am a practicing lawyer of Kotak, my lord, High Court, and it is very difficult on my part.
Sir, you should at least wear the coat, if not the band. You are a lawyer. Even though it is a in-person matter, you should wear the coat at least.
Only my lord, I thought I have in personal matter, I have everything.
In the personal appearance, I will coat up in the
Only my lord, I am wearing that.
Pass over. Next matter.
Item number 4,
I will plead one. But this is a petition filed by the wife, for transfer of the petition filed by the husband at Puri. And this wife is staying at Banki. There is a 110 kilometer distance from the place of the residence of the opposite party, and the case has been filed at.
All right, notice stay 7th November.
item number 5,
Item number 9, the petitioners were working as Shikshakas, claiming regularization in view of the order passed in the Dhananjay case. Similar,
Ranjay. Yes.
Yes.
All right, same order.
5 and 7.
Yes, 5 and 7.
7.
Same order, yes.
item number 6,
May I please, your lordship?
The petition was appointed as a mini Anganwadi worker. It annexed 1, but pay stay in election on an honorarium, monthly honorarium of 750 rupees miller. She worked to the certification of the authorities miller. She had upheld the maternity leave and thereafter he on 1/10/2013 miller. She was not allowed to work by the CDPO miller. I have filed a representation to the sub-collector miller by the annex of 2 miller.
No, but this is a matter of the year 2013.
But the CDPO assured him that
This is a stale claim. Completely stale claims.
supposing there must be some communication to him.
No,
You
no,
are just
no, no,
not
no, no. I can permit you to withdraw to pursue your representation, but I will not take cognizance of this matter. This is a 2013 matter. What are you doing? 11 years have passed. And how can this is absolutely stale claim?
The represent disposal.
No, no, I will not say that. You know, I don't believe in those things. Representation disposal more आगे दरकार नहीं. मुझे जेतिक आगे केस डिस्पोज ऑफ करी कंक्रीटली करी जेतिक हवा हो.
Section में तो कहीं की मतलब
ना 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 मोटे बिल्कुल कॉग्निजेंस ही नहीं मिले केस रो. बिल्कुल I will not take judicial notice of this case at all. This is completely stale claim. This is in April 2013. And you intend to join on 1/10/2013. Till date, according to you, you have not been allowed to join. What were you doing? What were you doing? This also will amount to abandonment of service. I have my own decision is there, abandonment of service.
but I think so was it notice
No,
action has been made.
No, Mr. Hoban. Either you withdraw or I will reject it. Permitted to withdraw.
Will you withdraw the pursue the represent?
Counsel for the petitioner seeks permission to withdraw the writ application as he intends to pursue the representation submitted by her before the sub-collector Kojaga, Koraput. Permission is granted with liberty as with no liberty. Permission is granted with the above observation. Yes.
item number 8,
Challenging the petition of the opposite party in not observing the petitioner in the post of accountant cum data entry operator, your lordship. Date of engagement of the petitioner is, your lordship, 25/4/2008. Date of joining 25/4/2008. Your lordship.
So that assists the matter.
No, my lord. This is
Different.
my lord. Because initially another candidate was selected in the post of GRS board, your lordship. Later on, she was disengaged and in that place the present petitioner was engaged, your lordship. Challenging the same, the another person challenged writ petition in a writ petition before this Hon'Ble High Court. The writ was dismissed against preferred appeal. Appeal was also dismissed. Thereafter, your lordship, the opposite party allow the petitioner to perform his duty. Your lordship, kindly see the page 41 annexure 5, your lordship. While
Page
the authority
41.
allow me to perform my duty.
Let us see. Inviting a reference, I am to say that the matter pertaining to the representation of Hiroj Kumar Acharya. Who are you? You are Hiroj Kumar Acharya?
Kumar Acharya, your
Hiroj Kumar Acharya for engagement as GRS, refer to law department.
the last paragraph.
Got it. Administrative Department is advised that Hiroj Kumar Acharya shall be appointed to the post of GRS with effect from the date he ought to have been appointed. However, he shall not be paid salary for the period during which. ये कौन है? What kind of opinion the law department is giving? Almost like an adjudicating like a writ court.
My lord,
Wait, Mr. Sahu. How? Anyway, yeah, therefore request.
Where is that he has represented?
No, the appointment in favor of the earliest as per the will. So, Director Special Projects directs the collector to engage him.
Fine.
Yes, then.
Your lordship, in spite of these findings, your lordship, performance report was also called for in the performance report. My performance was good given by my authority, your lordship. Thereafter also my candidature has not been considered by the collector, your lordship. The prisoner here also has submitted.
So, why are you referring to the other rules? That absorption in the accountant cum data entry operator? You have not yet been appointed as the Gram Rozigar Sevak.
My lord.
All right. We'll simply say that your representation will be considered. That's all.
Consider
His
the
prayer is also
finding
that.
No, that is what I'll say. The petitioner was. Where is that engagement order?
Engagement order, your lordship, annexure 1, your lordship.
Annexure 1 is about Panchanan Rona.
Engagement JRS,
So, the Panchanan Rona was engaged.
that is in that, in which place the.
Yes, that is what. So, initially Panchanan Rona was engaged.
Annexure 1 is the engagement order of the present petitioner in place of Panchanan Rana, your lordship.
Okay, here you are directed to disengage. Achha.
Therefore,
One Panchanan Rona was engaged as the GRS of Ko Jaga? Sanabausen Gram Panchayat under Bijaypur block of Balangir district, Bargot district. Stop. By order dated 25/4/2008 of the collector, said Panchanan Rana was directed to be disengaged with the further instruction to engage the petitioner in his place. Stop. This order was challenged.
this order was challenged by Panchanan Rana.
This order was challenged by Panchanan Rana before this court in WPC number 6542 of 2008. Stop. By judgment passed on 21/11/2016, the coordinate bench of this court did not find any infirmity or illegality in the order of the collector, and accordingly the writ application was dismissed. Stop. The said Panchanan Rana filed an intercourt appeal being WA number 548 of 2016, which also came to be dismissed by order dated 18/10/2022. In spite of dismissal of the writ application preferred by the disengaged candidate, along with the writ appeal, no steps were taken to engage the petitioner. The matter was referred to the law department by the administrative department. It appears that the law department, taking note of the dismissal of the writ application as well as the writ appeal, opined that the order of these that the petitioner should be appointed to the post of GRS with effect from the date on which he ought to have been appointed. Stop. Accordingly, the Director of Special Projects communicated, Director of Special Projects requested the collector to appoint the petitioner as GRS. It is the petitioner's grievance that despite such however, in the meantime, the petitioner was permitted to work as GRS and his performance was also certified to be good by the BDO of Tabira. It is his grievance that despite the above, comma, despite the aforesaid, comma, no order of engagement has been issued in his favor till date. Stop. Highlighting his grievance, highlighting such grievance, he has approached the Chief Development Officer, come Executive Officer, Jila Parishad, Bargod,
As well as to the collector, your lordship.
as well as the collector by submitting representation on 1/8 on
1/8.
1/8/2024. No action has been taken on such representations as yet.
It is his submission.
I will say if not taken up. The writ application is therefore disposed of, directing the collector, Bargod, to consider the representation submitted by the petitioner, comma, if not already considered, if not already disposed of, and to dispose of the same by passing a reasoned order within 2 weeks from the date of production of certified copy of this order. Yes.
Taking into consideration.
It goes without saying that in considering the representation, comma, the collector shall take note of the opinion tendered by the law department.
Item number 9.
9 is what?
Nine also similar order, your lordship, be due to pending of the vigilance case, corrected copy, your
Then-
lordship.
Yes, I'm disposing of in terms of Ashish Kumar Devata. Pass over to pass over.
Password item number 3.
I played before this one board matter, then I'm dependent on 5 in a suit in this civil the scenario on Bargod matter. I am aged about 24 matter, I'm unable to go there. At least this, your lordship may kind enough to.
You want it to be transferred from Bargod to Sambalpur
Or Kotak matter.
or Kotak?
I'm
All
suffering.
others are from Bargod.
Yes, sir.
Only one is from Sambalpur. So for them, it will be difficult to come to Kotak.
They have created some matter.
Only take notice. Take notice. Sir,
Yes,
take
sir.
notice.
Yes, all matter.
Yes, notice, stay. This is matter on 7th November.
Item number 10, password matter.
May I please, your lordship, that regarding the appointment of Hon'Ble worker, the Hon'Ble helper of another Hon'Ble center has been appointed.
Oh, that 2 clauses.
My lord,
Yes.
your lordship are directed to verify the clauses there in the helper, the locality word, your lordship wanted to verify. Whatever I verified, that from a decision rendered by Madras High Court, that has been specified. And locality means the area specified in the notification. And from other dictionary I have verified a specified area. That I have personally verified. So that also is similar to the service area as far as my knowledge is concerned. That the service area means a particular
I will
specified.
close it up. Yes, I will close it.
Sir,
I am closing it.
Ma'am.
Hearing concluded, judgment reserved. Parties may file their note of submissions and memo of citations if any within a week.
In this case, I am appealing for the opinion of file. I have already filed the VNMA, but not come in the list, my lord. So my name may.
Niranjan Singh.
Niranjan.
Niranjan Singh is appearing for opposite partner. Set out in the
Item number 11.
Then your lordship had directed me to prepare.
The original personal file of the petition has maintained the office of.
I'm sorry, that although my lord on 2 occasions my lord has wanted.
कौन लिखी थी मुझे पढ़ दिया बेटा no notice or show cause was served upon her before issuing the order of disengagement. The state council has however taken the specific stand that proper notice was served on. Since the original file is on record, the state council is requested to verify the same and to assist the court accordingly. Yes. What were you saying, Mr.
My lord, see, annexure number 4, page 23. Here, my lord, I have given it to right, my lord, last. Need type copy. My lord, see last page. Last page, my lord. Page 23. The answer is there, madam.
Hmm.
Further, final show cause was issued by office number such and such, which was duly served upon her as per the provision of CPC when she was found absent from home since long. So my stand.
তারপর আছে again paper publication was made.
So admittedly, my lord has made the query that whether this show cause has been issued and served to the person or not. I was not in a position to give a reply. This is the reply that it has not been served on me, my lord. And thereafter, advertisement was made on 30th July 2019, my lord. While in the advertisement they have made that within a period of 7 days you join. That is also in their counter they have admitted the 7 days. That means up to 7th of August 2019. They have terminated me on 9/8/2019, 2 days after.
Yes, what did you find out from the
Dead chart, your lordship may kindly.
তাকে দিলেন copy? Hey, Mr. Pandey, slowly, please slowly. Yes.
On 1/10/2018, Lady Supervisor Damayanti Jena reported the matter to the CDPO Courier that she visited the Anganwadi Center on 5/9/2018 and 25/9/2018, but petitioner was absent from the Anganwadi Center without any leave application. On 22nd October 2018, so-called notice was issued by the CDPO Courier to the petitioner regarding unauthorized absence from Anganwadi Center by letter number answer dated 22nd October 2018. Then on 31/2019, so-called notice issued through Lady Supervisor, namely Damayanti Jena, to the petitioner regarding unauthorized absence. On 2/2/19, so-called notice issued by the CDPO Courier to the petitioner regarding unauthorized absence from Anganwadi Center. Then on 12/3/2019, so-called notice issued by the CDPO Courier to the petitioner regarding unauthorized absence. 9/4/19, so-called notice by the CDPO Courier to the petitioner regarding unauthorized absence. Then on 15/4/19, notice pasted in the petitioner's house by the Lady Supervisor Damayanti Jena in presence of the concerned ward member and villagers for the so-called reply. So-called notice, then on 24/7/19, so-called notice was issued by the sub-collector Nuapada by letter number answer dated 24/7/2019 to the petitioner before passing disengagement order. Further, on 30/7/2019, further also, paper publication was made to resume her duty, which was published in the Daily Sambad newspaper on 30/7/2019. Then on 9/8/2019, since the petitioner did not turn up to submit her reply, the sub-collector Nuapada by order number answer dated 9/8/2019 disengaged the petitioner from the post of Anganwadi worker. Challenging the same, the petitioner had filed WPC number answer. The Honorable Court disposed of the writ petition with direction to the sub-collector Nuapada to take a decision. The sub-collector Nuapada on 10/12/2019, on the basis of direction of the Honorable Court upon perusal of the records, held disengagement order passed earlier. Upheld the disengagement order. Then on 20/2020, challenging the order, the petitioner had filed WPC number. The Honorable Court disposed of on 28/8/2020, directing the petitioner to file appeal. The petitioner filed appeal, and the appeal, the result was against her.
No, I will just, what I find is multiple notices have been issued, but have they been served?
And lastly, it was pasted since it could not be served.
Yes. But before that, all these notices, so obviously, unless there is an endorsement that notice was served,
Yes.
even one notice, if you can show me that it has been served, then probably she will have to explain. From the record, what does it show? You have the original.
It doesn't show that it has been served. Otherwise, it would not have been repeatedly sent to her.
Yes. She may have avoided it. That's all right. But it has to be served. So this notice was pasted on your house.
Ultimately, it was published in the newspaper. There are
No, notice was, what was published in the newspaper was to resume her duty, not about the show cause. Here, but one thing I will ask upon, I will call upon Mr. Chand to address is the notice pasted on the house.
No.
That you cannot avoid.
Let me see, where is that material? Rather, let me see, page, as I pointed out, page 23, need copy, let me see, that under the CPC, CPC what, with what type, in what way they absorb?
যা বুঝেছেন সে।
See,
So we'll do one thing, we'll not enter into this controversy. We will say that simply that give her an opportunity here. That's all.
As your lordship would direct.
appeal file kari sabu kala pare opportunity kala pare
The quasi period.
no
How so tell me, how can this court hold that no notice has been served when the notice has been pasted on your
pasted again way. If that is their submission, then Madam Messi, it is there in the note, although for the first time, 15/4/2019 notice has been pasted. 15/4 they have not said you will be removed from service. This notice was on 24/7. This notice was never posted. Madam Messi, last notice was on 24/7/2019 as per their own case, my lord. So 24/7 was never posted, my lord. And in the particular, thereafter, in the on 24/7, after 6 days, 30/7/2019, paper advertisement, you come and join. Nowhere, because before yes, they are my authority, they can throw me out. But before that, at least give you an opportunity, at least by saying if you will not join, we'll throw you out. At least that much, my lord. Neither in the particular paper publication, or also the final notice that 24/7/2019 has not been solved to me in any way, my lord. So if that the so-called notice has not been solved to me, and because of the fact that it has not been solved to me, after my joining report was not accepted, I approached the Honorable Court. And before that, I approached the authorities with the repension. The authority, the Honorable Court has directed that because of the pendency of the repention, you consider. Thereafter, all such things has been created, and the annexure 4, which was I have cited with the Honorable Court just now, is there. I have been told that the supplemental somehow afford the order of which, although he has, I don't know whether it passed it not, because the final order of disengage also not been solved to me. So neither this final show cause wherein they have intended to throw me out from the job was solved to me, nor also the disengagement was solved to me. Only after approaching Honorable Court, they have managed it, madam. And why I remain silent, it is definitely a genuine one because of the fact that I was in the particular hospital for the purpose of test tube baby, although I failed in that. I was in the hospital from 1/1/2019 to 14/7/2019 when the tutus was somehow terminated. And thereafter I joined in the, I approached the authority, they have not allowed me to join. I approached the Honorable Court and pursuant direction of the Honorable Court, my repentant disposal. And at that relevant time, I came to know that in fact, they have thrown me out from the job. And this 24/7/2019, it was never solved to me. And
all right, 24/7, all right. Let us ask him, let us keep it for a moment. But prior to that, 15/4/2019, the notice was pasted on your house.
No, this 15/4/2019.
Yes.
Accept.
So you cannot say that you are not aware of the.
I was not there. I was in the hospital.
15/4 you were on hospital.
Yes, my lord. Up to 1st January 2019 to 14/7/2019, I was at Raurkela. Test tube baby, and because of that, the complicated process is there. That's why I was at Raurkela, my lord. Completely, madam, see the record, I was at Raurkela. And that is the reason. And that's why from the very beginning, say, my lord, this maternity, dream of maternity is always a dream of a woman.
No, that's all right. That's all right.
And my lord has also, in one case, my lord made a judgment wherein my lord has considered this aspect to be a reasonable ground, and at this particular aspect, this should be considered liberally.
Yeah, that is true, but here.
And I am not for merrymaking or any other purpose, I remain upset. I do concede that I was my lord.
So what was the show cause notice? You have, if you have a copy, let us see.
The entire record I have.
Is it only for unauthorized absence?
Yes, my lord,
Records I have, I have flag mark.
I have also marked Annex 3. Karana Dasta notice. Page 18, 18.
Of the petition.
I have found, yes, sir. 18.
নোটিশ ଛପାଇବା ସମୟରେ ଉପସ୍ଥିତ ସଦସ୍ୟ ଓ ସଦସ୍ୟା ବୃନ୍ଦ।
Annex 3, page 18.
ରୁହନ୍ତୁ ମୁଁ ଏବେ ଫାଇଲରୁ ଦେଖେ।
ଆଜ୍ଞା।
There ought to have been some response from her side.
24/7 she has.
But if she can prove, even prima facie, that she was not present but was present at Raurkela, then obviously the notice could not have been served, and even pasting on the floor, on the wall of the house will have
Yes.
will have no impact.
That is correct. But what prevented her to make communications?
Yes.
otherwise.
Madam, see this particular annex of 3.
Where is the communication from your end? Where is the communication from your end?
In any mode.
You being in the employment, you cannot simply stay quiet.
No, I have.
Where are those? Where are those?
Madam. Just madam, can kindly have a glance to page 18, madam. Annex of 3, the earliest so called notice.
That I've seen, yes.
No, because it is their case that on 15/4/2019 they have pasted it. Where is that things available in this particular show cause? These things is absent. And this 15/4 notice was also not.
No, I want to ask you were at Raurkela. You are fully aware that you have been engaged as an Anganwadi worker.
Madam.
So it is also your duty
Yes, I
to inform.
Madam,
Where is the letter from your end?
Madam, I have.
Any sort of communication.
Yes. I have taken authority, permission from the authority, and they have also put their signature.
କାଇଁ ସେଟା କେତେ ରହିଛି?
Annex of Cornea, our appeal କରିଥିଲି.
ଲେଖି ଜଣେଇବାର ଏଇକି ଯେ ମୁଁ ଶ୍ରୀମତୀ ଗାୟତ୍ରୀ ମୋର ଗଲା 1/1/2019 ତାରିଖରୁ 1/7/6 ମାସ ସେ କେନ୍ଦ୍ରରେ ରହିପାରି ଅନୁପସ୍ଥିତ ରହିବି ଟେଷ୍ଟ ଟୁ ବେବି ପାଇଁ ଶାନ୍ତି ମେମୋରିଆଲ ହସ୍ପିଟାଲ
Technical document also show,
ମୁଁ
madam,
ଶ୍ରୀମତୀ
Tutus was terminated on the month of 7.
there are two I will ask you to take instruction because there are two letters written by her along with on 1/1/2019 both are on 1/1/2019 both seem to have been received by the CDPO, one by the supervisor, one by the CDPO with a seal. Please find out. Yeah. Why don't you file this by way of an affidavit so that I can ask him to he will either the ethnic କିଛି ଅଛି କି ନାହିଁ ଦେଖନ୍ତୁ ଆଗ verify it. Give him a copy.
Madam, what has happened, madam, the moment I joined, at the delivery time, all things was over. Madam, all right. The moment I approached the honorable court, somehow and
No, Mr. Chand, you see, you can validly argue that you have never been served notice. But if you can, there are two things that you have to show. First is that you had intimated the authorities that you will remain absent. You have produced something prima facie. Secondly, you have to show that during that period, this multiple notices being issued and being pasted on you were at Raurkela. So you could not have.
one madam. Madam, see the so called that they have given. It is now their case that on 15/4/2019, they have pasted it. The notice has been pasted. Madam, see, 15/4 notice is not there. Although 9/4 notice is there, but 15/4 notice is not there.
It is there in the record.
Yes. 15/4 that is not there.
Give a copy.
Aye.
Give a copy. In course of hearing, Sri Chand and counsel for the petitioner produces two copies of two letters written by the petitioner regarding her leave on 1/1/2019. He further points out that both these letters were received by the supervisor as well as the CDPO. Let copies of these letters be served upon the State Council, who shall obtain necessary instructions. List this matter on 26th September. So you have to, there are two things. First is whether you, and CDPO has endorsed it, unless the CDPO says that this is not my signature or something like that. Privacy.
Seal, then
There's a seal also. There's a seal also. And secondly, when the notice was pasted, she was admittedly, she claims to have been in Raurkela. So obviously that pasting of notice will have no impact. If this part is taken care of, then we have come to the next notice, which is 24/7/2019. That also does not appear to have been served. If then we will consider. Yes.
Item number 12.
Number 12 may remain taken up next week. 2011 matter. I mean, it's old matter. It's old matter. Perhaps I have also come prepared, but maybe taken up next week. Mike, because I have been here.
All right, place this matter next week. Next week, That's at a thirty to consider another day. Let's this matter. Let's this matter next week. The parties are requested to, the council for the parties are requested to come ready for final hearing.
Item number 14.
Pass over.
Item number 15.
Item 14.
15.
Achha, ho.
Next week.
All right, next week. Next week.
Item number 18.
Last time I received the answer copy filed at the offering of 7 mile. Paper to time to be returned.
Counter filed by the opposite party number 7 is served on the counsel for the petitioner in court, comma, who wants some time to file rejoinder there to place this matter on 26th September. Rejoinder, if any, be filed in the meantime.
Item number 19.
19 my lord.
Sorry.
One question. No, first item. Why the first item has been tagged with my
Apna
case?
each would question the diyo nako. You go to epote gote achi.
First item has been tagged with me. I do not know. My prayer is for regularization. His prayer for the challenge is the termination order. Then he has tagged my case. Then why I do not know. And I have filed the rejoinder not in the record. And also I filed the rejoinder on 22/11/2023. That is not in the record also. And my case may be decided separately because I have no nexus with that. Because we are continuing in our service and we have prayed for regularization. But what is his prayer? I do not know. But why this matter has been tagged with him? I do not know at all. And this may be decided separately.
There's an order
Clubbing up the matter.
by Justice Panigrahi tagging these two records. I don't know why.
My lord.
No, I have not
So let us do one thing.
Yeah.
Mr. Rathod,
Okay.
let us do one thing. Let Mr. Pandey begin. Let his matter. Let me consider. If it has got no nexus, I find that there is no nexus. I will detach.
More
detach.
regional
Down.
नहीं ତେଣୁ ମୁଁ ତ ଆଜି ବି
ନାଇଁ ଆପଣ ନ କରନ୍ତୁ ଆଜି ନ କରନ୍ତୁ ସିଏ କରନ୍ତୁ ତାଙ୍କ ପାଇଁ ସିଏ କରନ୍ତୁ
ତାଙ୍କ କେସ୍ ସେ କରୁ
My lord, here is a case, my lord. One advertisement was published in 2003. My lord, for 955 posts of Shiksha Sahayaks. Subsequently, my lord, a merit list was prepared and subsequent 15,000 some odd posts was again required by the state government. What government did, my lord, the person those who applied in the first advertised for the post of 9,500 some odd post, my lord, a merit list was prepared and those 15,800 people's, my lord, persons, the new created post, my lord, government observed them in the previous advertisement, which were advertised for 5,900, 5,058 posts only. That was challenged before this honorable court, my lord. In Hrishikesh Bandhani's case, this honorable court held, my lord, that the persons those posts was not advertised, they cannot observe from among the existing list owners. Thereafter, what happens, my lord? Many of the was appointed throughout the state were disengaged. My lord, on the same principle, my case was considered, I have been disengaged, your lords. But my humble submission is, my post is not coming under that 15,000 some odd post, those who have observed later. I was initially appointed, my lords, and for the post, my lord, 9,500 posts, I was applicant on that.
So you want to say that you are not covered by Hrishikesh Bandhani?
My humble submission.
That is the only thing that we see.
Thereafter, my another submission for lordships, my lord. Why my learned senior is I'm tagging this matter, pray for tagging this of this matter. These 46 persons, my lord, those who are placed with me in the similar footing, I have been disengaged. They're still continuing in the office. And there is a foul play.
So you can claim discrimination, but what nexus do you have with them?
My lord,
Except for claiming, Mr. Pandey, except for claiming parity. That since they are continuing, we should also continue.
My lord, that's why the honorable court, while hearing the matter in the previous dates, asked me how 46 persons were continuing when all the persons, those who are appointed illegal throughout this has been disengaged, how they are continuing. On few days, I'm out of court panel, I'm submitting. Few days, I'm inside the my lord, government school and mass education panel. I know, my lord, the foul play there. Some few officers handing gloves with the others, my lord, allowing this person to continue.
It should not be said like this, sir.
I got a
Please,
affidavit.
please.
File.
No, no, shunantu. See,
I have given an affidavit.
we are not concerned about it. We are concerned about you only.
Maybe you are the counsel for this some period. The communications which were supplied to you,
They were
the
privileged
counsel of them, you
They are-
should not be, you should not disclose it before
These
the.
are privileged communication, Mr. Pandey, let us not get
Please.
into that. Let us not get into that.
That's
You-
why
you-
out of court, I'm submitting.
No, no, all right, all right. I have not,
Friends should not be.
No, I will not take-
I'm submitting.
I will not take cognizance of those statements. But you place your case on your own merit. Your case is that you do not come within
I
that.
am
Hrushikesh Bindhani.
my humble submission and my lord, those participants still are continuing in the particular district.
Already you prove your case. That you do not come under Hrushikesh Bindhani. That you prove.
My lord,
My lord, in the past case,
Hmm.
before my learned friend will argue the matter, my lord. I think, my lord, he has not filed any rejoinder.
no.
So, my lord, on few occasions, my lord, an opportunity was given to file the rejoinder because we have specifically stated in our counter saying that the petitioner is an appointee in the second phase. So if he is not disputing the same, then it is up to him, my lord, to say. I have nothing to say.
But
To cover that particular issue of Hrushikesh Bindhani, the person, we have taken a specific stand in our counter saying that the petitioner could not come within the selection zone in the first phase. And taking into consideration the decision of the government for filling of the post in the second phase.
That 15,000.
Yes, ma'am. Thereafter, my lord, this petitioner is one of the beneficiaries under the second phase. So, my lord, if he is not disputing the same, that is a factual aspect what we have stated in our counter.
Definitely I'm disputing. Why not?
You file a rejoinder then.
Yes. My lord, I file, but my only submission, my lord, as per direction of this honorable court, I file an affidavit. That's those participants similar situated were still continuing in the post. I have been discriminated.
Let us accept it.
That instruction my
Mr.
learned senior has
Negative
not done.
equality, my lord, we will.
Mr.
My learned friend is not submitting that.
Mr. Pandey, two wrongs do not make a right. There can be no estoppel against law. A mistake committed by the authorities,
No one cannot substitute with another.
you cannot claim the negative equality.
But my lord, 46% are continuing only. I have.
So let us see whether the government has discriminated. But before that, the foundation has to be laid by you. So they have taken a particular stand in the counter and he has been magnanimous enough to point it out that you should file a rejoinder.
I should have.
So you take time to file a rejoinder.
I've taken time, my lord, a particular date will be fixed.
Yes, I will.
I'll
I'll file it on 26th September. You file rejoinder in the meantime.
But-
All right.
Well,
Then
only
comes-
pray that affidavit or instruction my lord, friend may be obtained.
Hmm.
Now they're continuing, that 46%. They are hit by the husband, brother. Throughout the state.
No,
all the personal
that order will depend on what steps, what stand you are taking in the rejoinder in answer to the specific plea taken by you.
affidavit by parts of direction of this honorable court.
You have filed.
Yes, my lord.
Where is that affidavit?
There is an affidavit.
Date कितने?
That is relating to 46 persons who are continuing. But you submit, you file a rejoinder with the specific.
Only I pray, my lord, in between the instruction of the correct case.
All right. Learned counsel for the petitioner wants to file rejoinder to the counter filed by the state. Further, this court observes that the state has not yet responded to the affidavit filed by the petitioner on 2/10/2023 regarding appointment of 46 other persons similarly claim to be similarly situated as the petitioner. Place this matter on 26th September. Rejoinder and reply be filed in the meantime.
Obliged.
Yes.
My case may be separated.
No, thou.
My regular is smooth to claim this regular.
ଆପଣଙ୍କର ଅସୁବିଧା?
Termination.
ଚାକିରି ଯଦି ରହିବ ନାହିଁ, regulation କରାଇବେ।
No.
Yes.
Why?
He is prayed.
Please.
Oh, yes.
Please. A judicial order has been passed by a coordinate
Now,
bench.
according to him, because in my absence, he has submitted before this case may be listed.
I will consider
This
it.
should be, my lord, your lordship,
should I
peruse
pray?
my,
Why
what
should
is
I?
my prayer and what is his prayer? And why this case will be tagged with.
Admittedly, you are one of those 46 persons.
We are the 46%, we are continuing.
You are continuing,
We are
yes.
continuing.
Yes.
Then we are prayed for.
He is not asking.
Service.
Sir, he is not asking for your disengagement.
My lords.
He is not asking for your disengagement. He is only claiming parity.
My lord, why this case will be listed along with it?
No, it will be listed. It will be listed. If you want to take time, you take time. No, not an issue at all.
No, your lordship only for, because your lordship see that my prayer is, what is my prayer and what is his prayer? No,
There-
prayer only prayer person. He then
No. It's not a question of prayer.
he
This court can call for any file for reference.
reference, yes, your
Yes.
lordship may reference, but I cannot argue because that may be for reference, but not for the adjudication.
Nobody is advocating
Adjudication,
it.
yes, so this may be only for reference. I do admit, no problem.
This is for reference. How can it?
This may not, that I may not participate in the hearing.
You don't
Because
participate.
he has challenged the termination.
Don't
I have
participate.
prepared for regulation.
Don't participate. Don't
Yes,
participate.
that should be not recorded because I will not participate in the
No.
only reference. Your
No.
lordship call for the record for reference. I have no objection.
My lord,
Your lordship,
on the submission of the submission of the
without my
Honorable State
knowledge-
Council, the Honorable Court was pleased to call for
No,
that.
why without my knowledge, why he has prayed for this and this only for reference?
Anyway, I'm not passing
Yes.
any order on that. Let it remain. It is only for reference.
Only for reference, yes. No, I do admit, my lord, I have also admit that this may be for reference, but I will not participate in because my prayer is separate thing.
He has got nothing against you. He has got nothing against you.
ସିଏ କହୁଛନ୍ତି ଯେ ସିଏ କଣ୍ଟିନ୍ୟୁ କରୁଛନ୍ତି ଆମେ କଣ୍ଟିନ୍ୟୁ କରୁଛନ୍ତି କାହିଁକି ହେଲା ସିଏ ମତେ ପାର୍ଟି କରନ୍ତୁ ମୁଁ କେମିତି କଟିକୁ ମତେ he should make party to us
Why?
otherwise he should not.
He is not asking for your disengagement.
My lords.
You will not be affected at all.
He has
He is only claiming to be
discrimination.
discrimination.
Yes, discrimination
Then state
because
to clarify, ଆପଣ କଣ କହିବେ?
discrimination say government will say
Huh,
that is
that
the
government will say.
huh,
That government will say.
but I will more prayer hochi I will pray something.
All right.
Your lordship only for your lordship.
All right.
Only for reference.
All right. Item 20.
Because in my absence, I may be absent on that day. Because in my absence.
No, order will be passed. No, order will be passed.
That's not.
Item 20.
In this matter, the petitioner is challenging the order dated order under Annex 7 passed by the LTMB Lord. 22/7/2021 passed by the LTMB, wherein the appointment of the present petitioner was cancelled and opposite party number 4 has got the appointment, even though the order is very clear that opposite party numbers last portion there order. In view of the above discussion, the selection of the respondent number 1 as Anganwadi helper in Kapleshwarpur second Saw Anganwadi center by the respondent number 2 is held illegal and hereby set aside. In the result of PG allowed. But what happened? Your lordship, I'm coming from the first. Your lordship, kindly have a glance. Annexure 6. Annexure 6 Miller, the procedure of appointment. Eligibility. At page 22. Your lordship, the Anganwadi helper procedure hochi selection procedure. Your lordship. Annex ସେଥିରେ ଇଏ ପାଇଲା 29ଟା ଭୋଟ ସିଲେକ୍ସନ ଯେତେବେଳେ ହେଲା annexure 1 ରେ ଅଛି ଇଏ ପାଇଲା 29ଟା ଭୋଟ ଅପୋଜିଟ ପାର୍ଟି ନମ୍ବର 4 ପାଇଲା 8ଟା ଭୋଟ ଆଉ ଜଣେ ଲୋକ ଗୋଟେ ଭୋଟ ପାଇଲା ତ ଇଏ ସିଲେକ୍ସନ ୟାର ହେଲା he joined the as Anganwadi worker helper. Thereafter your lordship kindly have a glance the opposite party number 4 who has got only 8 votes, he filed an appeal. After 2 months, he filed an appeal before the ADM, alleging that the certificate, school certificate, which has been submitted by the petitioner, is fraud one, and her age is more than 42 years. ସେଟା ସେ ଆଣିଲେ RTI ରେ ତାଙ୍କର ଟୋଟାଲ କାଉଣ୍ଟରଟା ସେ RTI ରେ ଯୋଉଟା ସେ ଦେଇଛନ୍ତି ଆନେକ୍ସର କରିଛନ୍ତି your lordship ସେଥିରେ ଗୋଟେ ଦେଇଛନ୍ତି କୁମାରୀ ମଣି ସ୍ୱାଇଁ କିଏ ମୋର ନା କୁମାରୀ ସ୍ୱାଇଁ କୁମାରୀ ମଣି ସ୍ୱାଇଁ ତାପରେ ତାଙ୍କର ଲେଖା ହେଇଛି ପିତା ମାର୍କଣ୍ଡ ସ୍ୱାଇଁ ସବସିକ୍ୱେଣ୍ଟଲି ମାର୍କଣ୍ଡ ସ୍ୱାଇଁଙ୍କୁ କାଟିକି ଲେଖା
ଆପଣ କୋଉଠି ପଢୁଛନ୍ତି
ତାଙ୍କ କାଉଣ୍ଟର ଦେଇଛନ୍ତି
ସେଟା କହୁନାହାନ୍ତି କାଉଣ୍ଟର ଆନେକ୍ସର
ଆଜ୍ଞା
Page 7 your lordship.
କୁମାରୀ ମଣି ସ୍ୱାଇଁ serial number 12 এই কাউন্ଟର
Yes, Kumari Mani Swai.
କୁମାରୀ ମଣି ସ୍ୱାଇଁ ସିରିଏଲ ନମ୍ବର 12 ତାର ତଳେ ଲେଖା ହେଇଛି ପିତା ଶ୍ରୀ ମାର୍କଣ୍ଡ ସ୍ୱାଇଁ
Hmm.
ତାକୁ କାଟିକି ପୁଣି ଲେଖା ହେଇଛି ଅରିକ୍ଷିତ ସ୍ୱାଇଁ
Hmm.
ସେ ଇଏ ବି ମିଶୁନି ହ୍ୟାଣ୍ଡ ରାଇଟିଂ ବି ମିଶୁନି ତ ଏମାନେ କଣ କଲେ ଗୋଟେ ଆରଟିଆଇ ରେ ଗୋଟେ ଡକୁମେଣ୍ଟ କ୍ରିଏଟ କରିକିନା ଅପିଲ ଫାଇଲ କରିକିନା ଆମର ଆପଏଣ୍ଟମେଣ୍ଟ ଟାକୁ ଇଲିଗାଲ କରିକି ନିଜର ଆପଏଣ୍ଟମେଣ୍ଟ ଟାକୁ ଧରାଧରି କରିକି କେମିତି ନିଜେ ବି ଆପଏଣ୍ଟମେଣ୍ଟ ପାଇଗଲେ ମୁଁ ରିଜାଇଣ୍ଡରରେ ଦେଇଛି ଯୋଉ ମୁଁ ରିଜାଇଣ୍ଡର ଫାଇଲ କରିଛି ସେଥିରେ ମୁଁ ଆନେକ୍ସର 12 ଟା କାଇଁ ଲେଭେଲ ଅଛି 11 and 12
Yes.
the document which I have filed initially I have filed Aadhaar card thereafter I have filed the medical side of the certificate issued by the medical Aadhaar card रे मोर date of birth होची 7/1982 मेडिकल रे जोटा मु डिपार्टमेंट ऑफ हेल्थ एंड फैमिली वेलफेयर डिपार्टमेंट जोटा देला मते ସେଥିରେ ବି ମୋର ଡେଟ୍ ଅଫ ବାର୍ଥ ହେଲା 7/3/82 ତ 7/3/82 ହେଲେ ମୋର ଏଜ୍ ଠିକ ଅଛି ସେ ଡକୁମେଣ୍ଟସ ଟା ଦେଇକି ଅପିଲ ଗୋଟେ ଫାଇଲ କରିକି ନା
Lordship may see the order at page 24. What my friend is saying that I have obtained the information through RTI and manipulated the
one more
name.
thing.
Just out.
ଏଥିରେ widow should be given preference ମୁଁ I am a widow
Lordship may see the CDPO Brahmagiri made inquiry into the matter and requested the headmaster Ma so-and-so school to verify the date of birth of the respondent number 1 Kumari Swain, daughter of Arikita Swain alias Kumari Pradhan, wife of so-and-so. And the report of the headmaster reveals that no student in the name of Kumari Mani Swain, daughter of Arikita Swain, has admitted in the school during 91 to 94. That CDPO has made an inquiry.
But the question is, she is not Kumari Mani Swai, she is Kumari Swai.
Kumari Mani Swain ta para puruna thila. Subsequently,
Application form ta dekhi. You have the copy? Produce the original
Yes.
file. You will see the application.
ମତେ ଯଦି ସାର୍ଟିଫିକେଟ ବି
ଆଉ
ଦରକାର
ଗୋଟେ-
ନାହିଁ ସେ ପ୍ରୋସିଜିଅର ରେ ସେ ଯୋଉ ଆପଏଣ୍ଟମେଣ୍ଟ ର ଏଲିଜିବିଲିଟି କ୍ରାଇଟେରିଆ ଅଛି ଆଉ ପ୍ରୋସିଜିଅର ଅଫ ସିଲେକ୍ସନ ଯୋଉ ରହିଲା ସେଥିରେ ସାର୍ଟିଫିକେଟ ର ହିଁ ଇଏ ନାହିଁ ପ୍ରଥମ ସେଇଟା ସି ମଷ୍ଟ ବି ଲେଡି ଅଫ ଦ ଲୋକାଲିଟି ସେକେଣ୍ଡ ହେଲା ସି ସୁଡ୍ ନଟ୍ ବି ଲେସ୍ ଦ୍ୟାନ୍ 18 ଇୟର୍ସ କୋଉଠି ବି ଲେଖୁନି କି ମୋର ଦ୍ୟାନ୍ 42 ଇୟର୍ସ ଯାହା ବି ହଉ 18 ଇୟର୍ସ ସି କ୍ୟାନ୍ କଣ୍ଟିନ୍ୟୁ in the job till discharge of duty efficiently the CDPO is competent to appoint and discharge the helper the helper preference should be given to orphan widows sever so they are
But
they
once
never-
there is a requirement to determine the age, and it is for it is the responsibility of the candidate herself to declare that basing upon which document she is actually establishing that particular age factor. So she relied upon that particular document, which later on, my lord, during the appeal, it was found that it was correct.
He has taken another plea that her name is not, that document doesn't relate to her.
Kumari.
Kumari Swai. So we do not know. So आपनका application देखले जଣା पड़ जो जात.
Will do.
तांका original application तो कर दिया थी वो.
what my friend is saying that I have manipulated her.
No,
the
you
name.
forget about it.
This is the original one obtained under RTI. The stamp is.
No. The question is, when the headmaster writes that no student by this
Absolutely.
name,
Absolutely.
that we have to find out. The original letter of the headmaster also.
Yes, my lord.
Lekhant. In course of hearing, Sri Rayat Singh, learned counsel for the petitioner, submits that the information obtained by the opposite party number 4 under the RTI Act does not relate to her, does not relate to the petitioner, whose name is Kumari Swai. Stop. The information relates to one Kumari Mani Swai,
daughter of Markandeya Swai.
daughter of Markandeya Swai. Stop. Further, the name of the father has been scored through. Stop. Learned counsel for the learned state council shall produce the original file containing the original application submitted by the petitioner and I would and the letter said to have been written by the headmaster of the school
Absolutely.
to the CDPO.
Yes.
Place this matter on
3rd October.
3rd October.
3 copy ଦରକାର
third.
ଅପଲୋଡ ହେଇଗଲେ ମୁଁ ନେଇଯିବି।
Third no, ma, out there. Third no.
4 weeks time ଦେଲେ ଆଉ କେତେ?
ମାନେ 4 weeks ମୁଁ ସେଇ particular ଟା ରହିବିନି ସେଇଥିପାଇଁ ସେକେଣ୍ଡ ଟା ଛୁଟି ଅଛି ତେଣୁ
ତାହେଲେ କେବେ ହଉଛି? ତାପରେ ଛୁଟି ହେଇଯିବ ନାଇଁ? ନାଇଁ ତାହେଲେ 26 ସେପ୍ଟେମ୍ବର।
25th election. 25th.
ନା 26 ତ ଆମର ଗୁରୁବାର ମାନେ ଗୁରୁବାର।
ଗୁରୁବାର।
Yes.
Here they have determined what is my.
ଛାଡ଼। Yes, 21 ଦେଇଛି।
Already.
Yes.
I don't know 22.
22, your lordship. It is the society registration certificate matter.
Yes.
Lordship, on the previous occasion, your lordship was
It was issued. What happened?
I
sir.
am appearing for the opposite pen number 9 and 14.
9 and 14. Yes. बोला notice matter is so all the respondents are now. Yes. The Soumyakanta Tripathi has entered appearance for the respondent number 9 and 14. He also files 2 affidavits on behalf of opposite party number 9 and 14. After serving copy on the other side, the affidavits be kept on record. Yes.
Lordship, senior counsel is out of session, your lordship. Maybe listed this any other date, your lordship.
Any other date means next week?
Lordship, 12.
Next week? 12th?
12th, I have a little difficult. Some matters are fixed, that is why. I may not be available. I'll try to be, but I can, that is why.
If there is any difficulty, we'll see. Let it come on 12th.
With that,
Let's this matter on 12th.
Interim order may continue.
Interim order to continue.
Okay.
Well, only may I permit
Yes.
make a submission? Well, so many allegations and counter allegations are there, man. Only one thing I want to submit, my lordship. Here, one certificate was issued in the year 1993. Referring to that particular certificate, when there was a request for extend the scope of operation, making it throughout the Odisha. A request was made to the IJR registration.
Yes.
And accordingly, a new certificate has been issued in the year 2023 and having a validity of 5 years. Now, that is not a challenge before this. Only I want to refer, subject to correction, my lord, referring that Society Registration Act 1860. Now,
The appeal provision.
no, there is a recent amendment in the year 2020.
Original suit is to be filed before
Civil
the.
jurisdiction. Civil.
I was responsible for that amendment, so I know.
So that may be the first issue which can be decided, my lord, on the next
That
day.
they can approach the concerned civil court.
So, my
I
lord,
think we have made it civil just senior division.
yes, ma'am.
Isn't it?
So, my lord, on the next date, when it is to be argued on merit, before that, my lord, that may be decided first so that we can proceed with.
That ground has not been taken by anybody.
no, I have taken that counter.
Taken
The
that-
counter.
You consider it.
Item 23.
I would have raised it at the outset, but it was before some other bench. It came to me. And there was some probably Raja Purburu gote kon thila because of interim order, some interim order was required. That is why I. Yes.
Challenging the order of the additional district magistrate Puri. But regarding the selection of the petitioners, of Anjanwadi worker man. In advertisement, the petitioner and the opponent sits. Both are applied for the Nijioda Kurti Anjanwadi Center 1.
My lord, on 29/8/2024, this matter was taken up by.
You filed your counter.
No, my lord. We had already discussed with the officer, my lord. 2 more documents I was actually requiring, my lord, which to satisfy the points whatever it has been raised in the petition. But actually they could not trace it out, my lord. So can it be taken up on 12th, my lord, so that on that day, my lord, positively I will file the.
2 times he has already.
Yes, I know that. I admit that.
Recommended that the para is already received.
My lord, here the draft counter is also ready, my lord. That is not what we are saying. We did not that, my lord, we are not prepared, and because through an incomplete counter, my lord, I think I couldn't, I am not in a position to help.
Appointed, applied for.
ହେଲା ଦିନ ହେଲାଣି ଆଉ ଗୋଟେ week ଏଟା 2024 matter କଣ?
It's a matter of 2024.
Sri Yasan Patnaik learned AG submits that he has prepared the counter, but he requires 2 more documents, which he has asked the concerned authority to furnish.
Yes.
Let this matter
On 12th, my lord, without
on
fail.
12th, counter be filed positively in the meantime.
Yes.
Otherwise, I will take it up
Yes.
whatever.
24.
I paid 2 times. Rejoinder last week.
Learned counsel of the petitioner seeks some time to file rejoinder. List this matter on 26th September. Rejoinder be filed in the meantime.
Item 25.
Second notice is counter se देना है.
না আসেনি এটা কোন 18777 প্রেবিসি
हाँ.
হ্যাঁ
हाँ.
Yes, your counter.
my lord, I think, my lord, there is a mistake on our part. There is an indication that on 16/8/2024 we have noted that, my lord, disposed of with the arrest. So we have not sought for the instruction. We may granted this sometime.
As requested by Learned State Council, is this matter on October? Hala, on 3rd October,
Yes, sir.
counter be filed in the meantime. Interim order to continue.
Item 27.
24 centimeter was there. 24.
24 में interim order to continue.
সেটা তো এক্সটেনশন হওয়ার লাগেছে আচ্ছা
Yes.
27 may I place it? The noting is there, my lordship, that notice has been on-served to the opposite party number 1, my lordship.
Take fresh notice.
My lordship. Interim order is there, my lordship.
Addressee can't be located. Addressee can't be located means
The address se
you serve a copy. Let the state serve. Let an extra copy of the transfer application be served upon Learned State Council, who shall cause the same to be served upon the opposite party through the IIC of the jurisdictional police station, indicating that the matter shall be taken up for hearing on
3rd October.
3rd October. Place this matter on 3rd October. Serve a copy.
my interim order.
Interim order to continue.
Oblige.
27.
Item 28.
This matter will also call for that report from the.
What report?
Under what circumstances, even after stay, the proceeding will continue.
A report was submitted to the extent that the order sheet was not available. It was again you lost about the directly learned justice to
ଲମ୍ବା ଚଉଡ଼ା ରିପୋର୍ଟ ଦେଇଛନ୍ତି ଆଉ
this at
ଲମ୍ବା ଚଉଡ଼ା ଲେଖିଛନ୍ତି ଆଉ ଏଇ ଏସିଆନ୍ ରିସର୍ଫେସିଂ
ସେଇଟାକୁ ବେସ୍ କରିକି ସେ
6/12/2021 ରେ ସେଟାକୁ ଷ୍ଟେ ଭ୍ୟାକେଟ୍ କରିଦେଇଛି ମୁଁ ଅର୍ଡର ସିଟ୍ ଆଣିଛି ତ ଟୋଟାଲ ସେଇଠୁ ତାପରେ ଏଭିଡେନ୍ସ ଡକୁମେଣ୍ଟସ ଫାଇଲ କରିବା ପାଇଁ କହିଥିଲି
As directed, the learned district judge Puri has forwarded the report submitted by the civil judge Puri. The report indicates in detail the steps taken by the parties on each of the dates. It is specifically stated that the order of stay of the proceedings was vacated by the predecessor of the present incumbent by order dated 6/12/2021, basing on the ratio of Asian resurfacing of road agency so and so. However, in view of the order dated 28/8/2024 passed by this court, the proceedings have again been stayed. Yes. The civil judge has requested to be excused for the mistake. Stop. Considering the explanation submitted, the same is accepted. The civil is accepted, that's all. Yes. What is this matter about, Mr.?
For the opposite party, my lord.
You are for the wife?
For transfer.
No, not
You are for the husband?
not the
Civil suit.
matrimonial dispute. This
Oh.
is civil suit. no,
Civil suit, yes.
Civil suit
Wanted to be transferred from which place to which place?
from Puri to Cuttack.
Yes.
Because initially the dispute relating to some monetary transaction in connection with house rent. The house belongs to the present petitioner. That is situated at Puri. The opposite party had taken it on loan, on rent. And that there was some amount which was not being cleared up by the opposite party, for which he issued a check. That check got degenerate.
It's a money suit.
It's a money suit. And that in connection with that check bouncing case, one proceeding is pending before this at Cuttack, London SGM Cuttack. That case was filed in 2017.
This is a fit case to send for mediation.
Yes, my lord, that is
This is a fit case to send it for
But
mediation.
mediation has failed many times. You lordship, direct. But
You never know. There is a monetary dispute, Mr. Mahapatra. It is not a very serious matter. Title involved.
It's not absolutely, I am saying also that is not a serious matter. Only the total amount, even in check bounce case, involved is 29,000. This opposite party is so adamant, he is not coming forward.
He will come forward. He will come forward. I'll fix it at High Court Mediation Center.
Yes.
What do you say? High Court Mediation Center ko jao. Yeah. In course of hearing, it is stated at the bar that the nature of the dispute is such as can be attempted. Nature of the dispute between the parties is such as can be attempted to be resolved amicably through the process of mediation. Hence, the records be placed before the coordinator Odisha High Court Mediation Center, who shall do the needful. The parties are directed to act pursuant to notice received from the mediator and to render full cooperation in the mediation proceeding. Place this matter November as well.
7th November.
On 7th November, interim order shall continue to the next date.
Item 29.
Last of the year was issue notice to the press jurisdiction.
Yes, further attempts, State Council to IAC.
Item 29.
PRPC number 282 of 2023.
Perhaps no copy was.
No, it was served on the last occasion. He said that despite repeated attempts, he could not, the notice could not be served, and he also did not respond to the phone calls made by the IAC. So I directed that further attempts be made.
So I beg apology. I will already copy.
All right. Land State Council requests for some time to obtain the current status regarding service of notice on the opposite party by the IIC. List this matter. What is short date?
19th September.
19th September. No, 26th September. 26th September. Take a time there.
Item 30.
On behalf of Mr. Paraj, I may be permitted to place on behalf of the petitioner. Here the petitioner, the digital wife will actually file the application. Husband filed the CP for divorce before the Reliance Judge Family Court Kotak, and the wife is residing at with her parents at Talcher. The nearest port is Hon'Ble Port, so she pray for
With the petition is pending at
Kotak LLC.
Kotak.
Reliance Judge Family Court Kotak. Kotak to Hon'Ble LLC.
Yes, what do you say?
My lord, she has filed the petition here while she was residing. Now he is residing at Culture. His presence is recorded at the time of evidence. That may be in VC 100 more.
विषय आपण appeal करू.
Sir, she may be.
Wait.
That lady, that petition may be.
No.
Moreover, section 24, notice not been taught to me.
आपण appeal କରୁଛନ୍ତି ବା?
No, sir, Talakot.
ତଳକୋଟ କୋଉଟା?
Talakot, they tell Annexure 394, that we are not been noticed.
Well, he will issue notice. He will issue notice before he can proceed. That goes without saying. So I'll allow the transfer. I will also grant you opportunity to appear to seek for permission of the court to appear through virtual mode. That's all. I'll allow it. Transfer application allow. Emergency you order to which you order to.
But both said.
Hey?
Both said are allowed. Transfer either seek or
Transfer application is allowed. You can also, if you want, you can appear through virtual mode by making necessary application. That's all.
Item 31.
Previous order kindly fail.
My lord, last petition inadvertently, it was told that I use file. But due to my clock accident, I could not file that I. It has been filed.
Today you filed.
Mine.
The 25 of 2024.
278 of 24.
That is not there on record. List this matter tomorrow along with IA number
278 of 24.
278 of 2024. It will come tomorrow.
Item 32.
May I begin to please your lordship, my lord? My lord, the petitioner is the wife and the OP is the husband. My lord. The OP has
Notice.
My lord.
What about notice? Notice was delivered, huh? There is no appearance. All right. You want it to be transferred from Kotak to Kendrapada?
Yes, my lord.
Lawyer and counsel for the petitioner is present. None appears for the opposite party. Despite repeated calls. Stop. Since notice was duly delivered, duly served on the opposite party, without waiting any further, the transfer application is taken up for hearing. Allow, could huh? Allowed.
All right, man.
Item 33.
Last year also is not common.
There's an interim mediation
Yes, ma'am.
27/9 को अच्छी तापर नवा आपका
It did ask nothing.
देखिए सी तो mediation टा close ही नहीं ना सी close को report दे देला सर the report of the mediator indicates that the next date of mediation is fixed to 27th of this month. Hence, list this matter on 3rd October. Yes.
Item 34.
Your lordship, I'm appearing in item number 34 and 35, lordship, on behalf of main counsel, Mr. Shyam Manohar. He
Yes.
is not well, your lordship, and we are humbly request you to kindly adjourn the matter for 1 week, your lordship.
All right. List this matter on 26th September.
Obliged,
34,
ma'am.
35 the time.
Both matters.
Yes, sir. All right.
Item 36.
No, for modification in I number, the present I is filed 1758/2024. In main order, author 1/24, in the para 5, 4th and 5th line, A second in place of second additional session judge, it would be STGM Khorda.
But that was corrected,
Corrected, but 5 star hoye
para 5 re.
para 5. In fourth and fifth varas, second additional session judge jagare STGM Khorda haba, higher forum jagare additional session judge likhe Khorda to session.
Code likha hai.
Prayer likhe. Para 5.
The words second additional sessions judge Khorda wherever occurring in order dated 18/1/2024 be substituted as SDJM Khorda. Yes.
तापरे the higher forum जगह additional session judge session judge ना
तो से हायर फोरम तो होबनी कोन से पोर्टफोलियो डिलीट कर दो हो
नहीं higher first
अच्छा हो further instead of the words higher forum occurring in paragraph 5 the words second additional session judge additional session judge Khorda be substituted.
37.
ये correction कर दो 37 automatic correction कर दो नोटिंग तो देखो चलो हमें correction करे तो अच्छी हाँ yes 38.
Appellant is filed interim bail, your lordship, on the ground of illness of his wife.
Interim bail. Regular criminal appeal, appeal in the nature of bail.
Nature of
Yes.
14. And serious, she has become within 3 months, she has become 2 times senseless, your lordship.
दले तो फाइल रहता हम entry mail hele bhi sir lordship 3 SCST is there.
Notice has to go.
Yes. I have a copy then.
Let an extra copy of the IA 2185.
Well, consider, your lordship. I'll serve.
I cannot. Unless notice is issued, how can I consider? Even any order to be passed has to be upon notice. That is the statutory mandate.
SCST is there. अरे 3 SCST.
आगुड़े दे देवे क्या कौन बीटा कॉपी दे देवे तो कौन IA be served upon the state council who shall cause the same to be served upon the informant/victim through the IIC of the concerned police station, indicating that the matter shall be taken up for hearing on 19th September. ଭଲ ତ ନିଶ୍ଚୟ ହେଇଥାନ୍ତା ଆଜି ବି ହେଇଯାଇଥିଲେ ଭଲ ହେଇଥାନ୍ତା କଣ କରାଯିବ ଆମ ହାତ ଗୋଡ ବନ୍ଧା ହେଇକି ଅଛି
Lordship, तार 2.5 वर्षर झियोटे केही मेल मेंबर नाहांती ओल्ड एलिंग पेरेंट्स ओनली सन्स 2.5 वर्ष लाणी भीतर
ଇଏଟା କଣ ମାନେ ଦଫା କଣ
302
ତେଣୁ କେହି ନାହାନ୍ତି ବିଚାରା ଏକଦମ ନିରୀହ ଲୋକଟା
out of sudden provocation, your lordship, dada boti marki ke
Already trial is going on. Pista witness. हाँ 6टा तो मैं जाने चाहिए exam में.
already you give, you will see on 19th ତା ପୂର୍ବରୁ ହେଇପାରିବ ଗୋଟେ week ନଦେଲେ କେମିତି
17
19th
गुरुवार
ଗୁରୁବାର
and not that's why
20 ତାରିଖ 20th
yes
this is matter on 20th ହେଲା
I will also bring instruction on that IA also. So,
further the state council shall also obtain instructions with regard to the amendments made in the IA.
Item
IA
39.
copy टा देबे नाले आसीबनी.
39
80 दे देबे आनी एबे दे दे.
May be your. The petitioner challenges order under annexure 5 at page 54. Wherein learned.
It is a 482 matter.
Malo.
482.
Malo.
Why has this come to me?
Because one of the application disposed of by your lordship.
Of the same accused.
Aye. सेटा इश्यू थिला एनबीडब्ल्यू इश्यू हितला
एथरे कोन हितला I am of the opinion of prima facie case discharge petition is rejected.
Yes, Lord. Lordship, the discharge petition has been filed as per direction of this honorable court. What happened? Earlier discharge petition was rejected. The present petition challenged before this honorable court, and this honorable court, while disposing that CLMC application, directed the petitioner to raise all the points raised in the CLMC petition before the trial court. And the petitioner has filed the application under Annexure 4 at page 41, raising all the points taken in the CLMC application before the learned trial court. The learned trial court has not touched any of one point raised before that court, and basing upon the earlier order, simply rejected the application for discharge, my lord. What happened in the earlier writ application, CLMC application, notice was issued to the opposite party number 2 twice.
Informant.
Complainant.
Yeah,
Arising out of a protest petition, my lord.
Yes, yes.
Initially.
So let us issue notice
Again.
now. Let us issue notice.
Again.
We'll stay the proceeding. Okay.
Again.
It has been also, the petitioner also filed revision against that discharge petition. It has been upheld, madam.
Earlier, my lord.
Page 56. Last.
No, against this order.
No.
The impugned order has not been challenged. Or additional notice to the opposite party number 2 by registered post with AD returnable within 4 weeks. Requisites be filed within 3 working days. This matter on 7th November. IA. Further proceedings in such and such case shall remain stayed till the next date.
Lordship, I will take notice on both the address of the opposite party now too.
अच्छा हो तापर notice be issued on notice be issued to the opposite party number 2 on both the addresses mentioned in the cost title, for which requisites appropriate requisites shall be filed.
Obliged.
Dita file କରିବାକୁ ପଡିବ ଆପଣଙ୍କୁ
ଆଜ୍ଞା ମୁଁ ଦିଟା କରିବି କାରଣ ଆର୍ଲିୟର ଇଏରେ ଆଡ୍ରେସ ଆସି ନଥିଲା ସେ ଇଏରେ ତ ପ୍ରେଜେଣ୍ଟ ଆଡ୍ରେସ ମୁଁ କଲେକ୍ଟ କରିକି ଦେଇଛି
yes
item number 40 urgent copy
Petitioner is in custody since 29 2021.
The bail?
Yes, ma'am. Bail, my lord. And I have filed a IA that has not come released, my lord.
That Sunita Das has been examined.
Yes, in the meantime.
But I am supplying.
And she has corroborated her statement in the 161, 164 and in her evidence also.
My lord,
The 376 matter?
No, my lord, 302.
302, let us see.
my lord, kindly have glass to FIR, my lord.
मुझे आगे पढ़ते हैं क्या? सुनीता दास का पढ़ते हैं?
Para 3.
What is your name?
My lord, Prashant Bhoi.
Sashikanta Bhoi. On that day at morning, Munna Behra, Lakshmindra Behra, Bhubaneswar asked for fitting of sound system in a village clubhouse and to dance all together. Accordingly, at about 9:30 p.m., Munna Behra and Lakshmindra provided the music while the son of Dilip Bhoi. ଏଥର ଯଦି ପୂଜା ହବ ନିଆଁ ଜଳିବ ଆଚ୍ଛା ହଉ ହିୟରିଂ ହେଲା ସୁରେନ୍ଦ୍ର ବେହେରା ପବିତ୍ର ବେହେରା ବୈକୁଣ୍ଠ ବେହେରା ରମେଶ ଦାସ ଜୟନ୍ତ ଭୋଇ
Prashant Bhoi.
At that time, Jayant Bhoi, after that.
Jayant Bhoi assaulted to the head of the Pavitra Behera with the handle of Kanko and Prashant Bhoi
hacked to the head of the
Bhoi with the Kottari, মানে Kotturi.
Yes.
Then Pavitra Bhoi, Vikas Bhoi, and being out with them. Yes, Dr. Paul.
Yes, my lord. Kindly have glass to FIR, my lord. My lord, here, my lord. I am stating, reading the FIR, my lord.
What do you want?
From the
ପୁରା ତ ପଢିଦେବେ ଆଉ
ଗତ 19/9/2021 ରାତ୍ର 8 ଘଟିକା ସମୟରେ ଆମ ସାହି କ୍ଲବ ଘରଠାରେ ଆମ ସାହିର ପିଲାମାନେ ଖୁଦୁରୁକୁଣୀ ଉପଲକ୍ଷେ ସାଉଣ୍ଡ ବକ୍ସ ଲଗାଇ
10 ଘଣ୍ଟିକା ଲେଖାଇ ଯାବେ 8 ଘଣ୍ଟିକା କଣ ପଢିଲେ
10 ଘଣ୍ଟିକା ରାତ୍ର 10 ଘଣ୍ଟିକା
8
ନାଇଁ 10 ଘଣ୍ଟିକା
2 ଘଣ୍ଟା କାଟିଦେଲେ ପୁରା
ଖୁଦୁରୁକୁଣୀ ଉପଲକ୍ଷେ ସାଉଣ୍ଡ ବକ୍ସ ଲଗାଇ ନାଚୁଥିଲେ ଏହି ସମୟରେ ପ୍ରଶାନ୍ତ ଭୋଇ ପିତା ସୁଆଂଶୁ କ୍ଲବ ପାଖକୁ ଆସି ଅସଭ୍ୟ ଭାଷାରେ ପିଲାମାନଙ୍କୁ ଗାଳି ଗୁଲଜ କଲେ ମୋ ବାପା ପ୍ରତିବାଦ କରିଥିଲେ
ଆମ ପିଲା ମାନଙ୍କୁ କାହିଁକି ଗାଳି କରୁଛ? ହଠାତ୍ ପ୍ରଶାନ୍ତ ଭୋଇ ଓ ତାର ଭାଇ ପ୍ରଫୁଲ୍ଲ ଭୋଇ ଓ ତାଙ୍କ ପିଲାମାନେ ପବିତ୍ର ଭୋଇ, ଜୟନ୍ତ ଭୋଇ ଉଭୟଙ୍କ ପିତା ପ୍ରଫୁଲ୍ଲ ଭୋଇ, ପ୍ରକାଶ ଭୋଇ ପ୍ରଶାନ୍ତ ହାତରେ ଏକ କଟୁରୀ ଠେଙ୍ଗା ଧରି ମୋ ବାପାଙ୍କୁ ଆକ୍ରମଣ କଲେ। The occurrence took place all of sudden, my lord. And the last witness, my lord, Sunita Das also stated that I am giving the copies of the deposition.
Of Sunita Das?
Yes, ma'am.
The court has forwarded. I have it with me. पढ़िली ना पढ़िली पर देखले परा प्रशांत भोई हैक टू द हेड ऑफ बैकुंठ बेहरा विथ कटुरी
Yes, my lord.
तो मुंडो को कटुरी आपण मारले
Yes, my lord.
सडन प्रोवोकेशन हो ना हो 304 part 2 हबो कि 302 हबो whether it will amount to culpable homicide I mean amounting to murder or not amounting to murder is a matter to be decided finally at the end of trial, but there is prima facie evidence to show that you hacked him by means of a koturi on his head. The intention is very clear, so
Sudden provocation.
so bail is rejected.
But I have filed an interim bail, my lord. Costed in.
Direct evidence no interim bail, only under emergency medical situation I can consider.
I have filed a IA, my lord.
कौन हिचे अपनो देखिए आइए এটা দেলে
The ma.
সুমিত্রা বই মা
Wife, my lord. I have.
এটা কি সুমিত্রা বইটা কি
have you given copy Paul?
just now
Yeah, you
এটা কি তোমার
The wife.
বরাবর
you take instruction
Present its wife of.
you take instruction Mr. Mishra.
yes ma'am
Learned counsel for the petitioner files it IE এটা ଅଛି is it on record? No, it is not on record. Where is that IE? IE टा नहीं इसमें number ही है तो आज नहीं इसमें IE order टा कर दूँ से bring it to them. IE 1162 of 2024. This is an application for interim bail. Let a copy of this application be served upon the State Council, who shall take instructions with regard to the documents enclosed there to place this matter on 26th September.
Item 41.
Offense under section 302 and 307 and other allied offences. And the accused.
Normally,
7/4/2023 mile. And both the family dispute between vegetables and tarbuja selling that dispute. Both are neighbor to each other, my lord. And the occurrence day on 9:30 night, both family with armed with force and tussle between them, and the old man, the father of the informant, he died. ସମସ୍ତଙ୍କର ହାତରେ ଛଡ଼ ଟାଙ୍ଗିଆ also informant also ବି ସେ ବି ଗୋଟେ ଅସ୍ତ୍ର ଧରିକି ଏଇ ସମୟରେ ଏଇ ବୁଢା ଲୋକଟା ପଶିଗଲା ତାକୁ ଛଡେଇବା ପାଇଁ and specific allegation କାହା ମାଡରେ ଆଜ୍ଞା କି ସେ କିଏ ହେଇଛି ମୁଣ୍ଡଟା ମାଡ ହେଇଛି
I have granted bail to one Narendra Meher.
Narendra Meher
Because allegation against him was that he was Thenga.
ଠେଙ୍ଗା
And there was no-
but ଆଚ୍ଛା
ତାପରେ ଇଏ ରଞ୍ଜନ ମେହେର ଗୋଟେ ଛଡ and ଉର୍ମିଳା ମେହେର ପନିକି କିନ୍ତୁ ସେ ଚାର୍ଜସିଟ୍ ହେଇନି.
That I've taken note of.
Then ଇଏ ଟାଙ୍ଗି was seizure.
Seized from the present petition.
ନା ସେଟା
Blood stain tangi.
27
Disclosure.
ପଛପଟେ ଦି ଜଣଙ୍କର ବାଡି ସେଠି ନଡା ଗଦା ଭିତରେ ସେଟା ପଶିଥିଲା. That is the extrajudicial confession ଯୋଉଟା.
Extrajudicial. Disclosure.
Fine. And 9:30 AM ଅନ୍ଧାରରେ ଆଜ୍ଞା ଉଭୟଙ୍କର ବଡ ବଡି ହେଇଛନ୍ତି. ଏମାନେ ବି କିଛି ଛୋଟ ମୋଟ ଇଞ୍ଜୁରି ହେଇଛନ୍ତି. କିନ୍ତୁ ଏଠି ସ୍ପେସିଫିକାଲି କାହା ମାଡରେ ସେ ମରିଛି ସେଇଟା ନାହିଁ. And
If I give the postmortem report, postmortem report says incised wound.
Incised.
ମୁଣ୍ଡ ଫୁଣ୍ଡକୁ ମାଡ ହେଇଛି. ଆଚ୍ଛା
Incised
ମୁଣ୍ଡକୁ
wound.
ମାଡ ହେଇଛି.
The occipital
ସେଇଟା
region.
ତା ପୁଅ ବି ଧରିଛି. ଯେହେତୁ ବୋଥ ଭିତରେ ପଶିଲା ବେଳକୁ ସେଟା ରାତିଟା ସ୍ପେସିଫିକାଲି କାହା ଓପେନରେ ସେ ଇଏ ହେଇଛି ସେଇଟା ନଟ୍
Banumani Meher assaulted the deceased by means of an axe. This is very clear from the FIR itself.
ସେ କହୁଛି
Narendra Meher by means of a thenga, Ranjan Meher by means of an iron rod, and Urmila by means of a kitchen. I have found the discrepancies and therefore I have granted bail to Narendra.
From the postmortem.
But you don't stand in the same footing at all.
No.
No, Mr. Mahapatra.
same footing as per ନାହିଁ that is true my lord.
That is only true.
Specifically ଯେ କାହା ମାଡରେ ସେ ମରୁଛି ସେଇ ସ୍ପେସିଫିକ ଟା ନାହିଁ
ଦରକାର ନାହିଁ 34 ଅଛି ବା 34 is there.
34 is well made out
ହବ
ସେଥିରେ କିଛି ନାହିଁ କିନ୍ତୁ ଯେ ଏଇ ଗଣ୍ଡଗୋଳ ଭିତରେ ଜଣେ ମରିବ ଏ ପ୍ରକାର ଇଣ୍ଟେନସନ ବି ଆଜ୍ଞା ନାହିଁ ତା ଦେହରେ କିନ୍ତୁ ଯେହେତୁ ଗୋଟେ ଛୋଟିଆ କଥା ଯୋଉ ମାନେ ତରଭୁଜ ବିକେରୁ ଇଏ ଗୋଟେ ହାଟରେ ସିଏ ବସିବ ଇଏ ବସିବ
Whatever may be the reason, whatever may be the motive, when there is direct evidence, motive loses its significance. There are direct evidence ଅଛି ଆଉ କଣ କରିବା?
Let some witness, eyewitness may be examined.
You may renew your prayer after examination of the eyewitnesses. You may simply seek withdrawal to examine, to renew your prayer after examination of eyewitnesses. That will
Injured
be,
eyewitness
I will
is
not
also
reject it
there.
now. So why the rejection may stare at you in future. But if you withdraw it and if the witnesses do not say anything in the court, you can be released immediately. All right. Who are those witnesses?
My lord, one injured eyewitness is Bhagwan Meher. After
Bhagwan
that,
is the son of the
a son of the, is a Khiro Meher, Vibhuti Meher, Sankarshan Meher, Rabindra Meher.
5.
5.
All right. Learned counsel for the petitioner seeks permission to withdraw the bail application with liberty to renew his prayer after examination of the eyewitnesses. The eyewitnesses. Eyewitnesses. Stop. Permission is granted with liberty as aforesaid. Liberty as aforesaid. That's all.
I am present.
item 42.
May I please? It is the offense under section 302 and 34 of IPC.
Yes.
That,
Kipti Kumar Tripathi.
the present petitioner was charge sheeted on the basis of investigation taken by the IO, and the FIR was first of all, the case was registered under UD case, registered UD case. Thereafter, on investigation.
I have granted you twice interim bail. That is all. That is the only relief that you will get. How? A very heinous offense.
My lord, my name is not there first.
I have considered it. I have considered it. I have considered it. You have filed. This is the fourth application, isn't it? DLAPL number 6632, 76 of 2022. No, this is the third. This is the third application.
Third, two,
Okay.
then third one.
I have granted you interim bail. Whatever relief could have been granted to you under the circumstances, I have granted you already.
My lord, my prayer is that I was not, my name was not in the affair. Only on the basis of the statement, who was also.
You are the owner of that entire rehabilitation center,
Yes,
the Fruta Foundation.
There is,
I have taken note of it. You are treating, very recently in the newspaper, there was a report about the brutalities being committed by these so-called owners of the rehabilitation centers, where the drug addicts are tied by iron chains, beaten and all that.
Many
I
cases,
have got nothing to do with your case, but here there is a person has died.
many cases across the state, ma'am. Jagat Singhpur, Balisar.
And the trial is going on.
Trial is going on. Already 10 witnesses examined.
very after that, the deceased has been named as witness number 2 as victim witness.
ସେଗୁଡା ଭୁଲ ହେଇଥିବ ସେଟା କାଟିଦେବ ସେଟା କଣ ସେଟା ଗୋଟେ ଭୁଲ ହେଇଥିବ.
I was not present in fact.
No. You may not have been present. You may not have been physically present, but
But the
120 ଥିବ 120B,
no, 120, there is no 120.
34 ଥିବ.
34, there is 34.
Yes, 34 is there, ma'am.
But matter of fact that the person in whose name the affair was registered at first, he was
Sir, listen. Whatever relief could have been granted to you, I have granted you. No further relief. It's up to you. Either I'll reject your application or you may withdraw.
I will withdraw, but
Permitted to withdraw.
kindly say speedy trial, man.
Permitted to withdraw. The court below is directed to expedite and conclude the trial as early as possible. Yes.
Item 43. Eight resolution. But I have already solved the deposition copy of the eyewitnesses, including
Ajay Barik.
the main eyewitness Ronco Jena Miller. The bail application.
ଅଛି ଅଛି ସବୁବେଳେ ଅଛି.
Ronco Jena जो earlier rejectedଥିଲା on the basis of
You have been rejected earlier and you have been granted interim bail.
Ronco Jena has been examined and another 9 eyewitnesses has been
He has
examined.
been to apex court and there also.
Then ସେଟା interim bail ହେଇଥିଲା, interim bail ବି extension ହେଇଥିଲା, subsequently ଆଉ extension କଲେ. ତାପରେ eyewitness ଯୋଉଟା examination ହେଇଯାଇଥିଲା କହିଥିଲେ eyewitness ଯୋଉ Ronco Jena basis of which application was rejected and the 164 statement those who are also eyewitnesses they have been examined and they are not also stating anything in number 9 I have given my last out 3 janakar bhi de deji. And also the
All are not eyewitnesses. Among 9, all are not eyewitnesses. And apart from that, several eyewitnesses are also there, my lord. One Simanchal Barik, one Rabindra Swai, Ranjan Kumar Naik, and one Arikita Parida, Santosh Kumar Sahu.
You keep it pending, let them be examined.
Several eyewitnesses are there, my lord. More than 12 to 13 eyewitnesses.
Another thing, my lord,
This is a firing case.
your lordship
Yes, my
kindly,
lord. Firing
here,
case.
my lord, your lordship has also observed. I have, my lord, in the investigation, while granting bail to one, my lord, Gagan Biswal.
No, they are on different.
No, it's helpful for it. Page 38, my lord. While granting in the investigation, page 38, my lord, 4th paragraph, 3rd line of the bail application. In course of investigation, it was revealed that deceased was first shot at by one Balaram Parida and thereafter by one Ajay Barik and Pavana started indiscriminate firing, causing of his death. Based on the final investigation, my lord, final investigation, page 24. So, lordship has also paragraph, my lord, 14th line. The accused Balaram Parida came to the tea stall by the firearms and opened fire pointing on the backside of the deceased. Then the accused Ajay Barik and Pavana came to the tea stall and started indiscriminate firing. All the witnesses have stated, my lord, to lordship, that's why the investigation reveals. Balaram and all the witnesses have stated, Gora Patala Pilata fast match, then thereafter. So investigation reveals that Balaram Parida, who is the, my lord, that person, has started fast firing. That's why while your lordship has granted that by taking into that observation also, your lordship that observed. So Balaram Parida was the first, my lord, and whose, my lord, gone was seized. Now seizure witness has also been, my lord, taken as a hostile. And basing upon the Ronco Jena statement earlier, lordship earlier rejected, on the basing upon the London State Council has placed the statement of Ronco Jena. Ronco Jena has also been PW1. He has also not supported the and PW. And another thing, when I am pointing out, 164 statement of my lord, the lordship kindly, I have annexed the 164 statement. Those who are also
Sir, what I am saying is, please wait. Let the other eyewitnesses be examined.
16 Panchadod, my lord.
No.
The audios.
No. This is a case, firing case, murder case.
16 Panchadod.
Dangerous criminal, what are you saying?
And this person has specifically identified.
No. I will never get
and
it.
the person granted bail, driver of that vehicle, he was not present at the spot. And another only.
No, Mr. Manjada, keep it pending. Keep it pending. Let the others,
yes, ma'am.
let the other witnesses be examined. Then one can consider. No, I will not. Jahi chichi, I will say on you. No. Yes, please, this matter, November, on 14th November. Yes.
Simanchal Barik, Rabindra Swai, Ranjan Kumar Naik, Arikita Parida, Santosh Kumar.
They may also turn hostile. Some of them, if they turn hostile, I will grant bail.
Yes, ma'am.
I will grant regular bail. Don't worry. Don't worry, don't worry. Short date হবনি নভেম্বর হবো তাতে ছুটি পড়ি যাଉଛି হবো কেତେବେଳେ?
Mean time ଆମେ examine ହେଇଯାଇଛି।
ହେଲା କାଇଁ ବ୍ୟସ୍ତ ଏତେ କଣ why are you so? Yes, item 44. No, no, no. No, no, no. Item 44. Yes.
44.
May I please your lordship? Present petitioner, my lord.
Deposition copy have been served.
Yes,
Yes, my lord.
Present petitioner is behind bar since 1/2/2022, my lord. Being charged under section 498A, 304B, 306, 34 IPC, along with the offence of 40 Act, my lord.
You are Satyajit Malik.
Yes, my lord. On identical allegation, sister-in-law of deceased, who has also been named in FIR, has already been released on bail, my lord. I want to invite my lord's attention.
Out of 38.
Yes,
Well,
sir. Sir, bail application of the present petition was refused by this honorable court by the PLPL number 11751 of 2022, my lord, on 4/5/2022, my lord. With a specific observation, after examination of the informant, liberty is granted to renew the prayer for bail, my lord. Thereafter, my lord, lordship finds, in the meantime, 25 witnesses have been examined. Out of 25 witnesses, my lord, PW 22 is the informant of the case.
Let us see.
Yes, my lord. I have given Sajni, who has supported the prosecution case.
22, 24.
And another is PW 24 have supported the prosecution in some manner, my lord. Other witnesses, my lord, independent witnesses have not supported the prosecution case in any manner, my lord. I want to invite my lord's attention, the evidence of the PW 22, which evidence suffers from material contradictions. That
Just a moment, Mr. Das. Let me just read the chief.
Yes, ma'am.
Like you, Satyajit Malik is the husband of Mrs. Josie Malik.
Para 4.
He is not an eyewitness, obviously.
No.
No, man, not eyewitness.
He is the father of the
girl. Deceased is my niece coach. Examination
Niece
paragraph
daughter.
number 1.
My elder brother.
I am the informant in this case, and he has also stated his evidence suffers from. I want to invite with my lord's permission. I am placing. I want to invite my lord's attention. His cross examination, my lord. Paragraph 9, my lord. Entire evidence suffers from material contradiction, my lord. That apart, my lord, he has also further admitted in his cross and paragraph number 10 with regard to the first FIR story, my lord. Paragraph 10, my lord. I have not kept any FIR of my first FIR, which I had submitted to IIC Campbell PS, my lord. Paragraph 8, my lord. He has also admitted that.
So what other evidence is there? Except for
24, your lordship.
That evidence also, I want.
Who are my sister-in-law.
Sister-in-law, my lord.
Paragraph 4 is relevant. Every time there was a quarrel.
But in paragraph number 10 of his cross-examination, this witness admitted, I was not examined by the police in this case, nor I have given any statement before him in connection with the case, my lord. It appears from the record, my lord, he is a witness to the inquest, my lord. And he has also admitted in his cross-examination, my lord, paragraph 10, my lord, I can make paragraph 10.
I've read it, I've read it.
I was not examined by the police in this case, nor I have given any statement before him in connection with this case, my lord. In this offense 304B not punishable with capital punishment like 302, my lord.
Life imprisonment.
Other material witness and family members are yet to be examined.
May extend to, my lord. Maximum 7 to 10 years, my lord. Lordship, that
I have granted you twice interim bail.
conduct is very orderly and excellent, my lord. He never misused the
No, this
liberty,
person, excellent conduct of court, which is
never
the
misused the
one who kills his wife.
Lordship knows that nowadays all the doubtless case becomes
no,
MACT case.
no,
my
no,
lord.
Assault,
I'm not
torture,
glad.
That
from
is-
the-
that
I've
is-
already granted you twice interim bail, and that is the only relief that you put.
There is a slow progress of trial.
Slow, 25
Your
witnesses have
lordship,
already been examined.
Your lordship, that PW 22, my lord.
There is at least some proof, evidence regarding
Before
demand
death,
for
there is
dowry.
no evidence, my lord. Soon before death, my lord, there is no evidence, my lord. There is no independent corroborations, my lord. There is no independent corroborations, my lord.
last witness
And-
examined on March 23, almost
PW
1.5 years.
That I can expedite the trial.
And-
I can expedite the trial, or you may file an IA again seeking interim bail. That can be considered because of the delay in progress of trial.
That is very slow, your lordship, dispose of application by granting interim liberty and direct the trial court to conclude the trial, my lord. Lordship, even if your lordship has granted liberty, my lord, to renew his prayer for bail after examination of the informant, my lord. The informant examined on 11/11.
That I was seeing. I was looking at my previous order. I remember, even though I have noted that there is some contradictions, inconsistency in the statement of PW 22, the informant, still I was not inclined to grant regular bail.
Bail, my lord, section with period of detention, lordship, views of the apex program, bail is a rule, refusal is an exception.
No, not in all cases.
But in the
Not
case
in
of-
all cases.
Case, my lord, on identical allegations, daughter-in-law has already released on bail.
He is the husband. He is the husband. How can there be a parity?
And soon before her death, my lord, there is no evidence, my lord, to raise presumption
No, no,
113B, my lord.
no, Mr. Das, I'm not inclined.
Lordship, may
No.
grant some interim bail and interim bail. Your lordship's
Yeah, I will grant you the interim bail, but you
Thereafter-
just file an
thereafter
IA.
there is no-
Take it
Thereafter,
up.
there is no progress of trial, my
You
lord.
file an IA, I will grant you it. Since there is a delay in trial, so you may, yeah. Please, this matter next week as paid for.
45. May I please, lordships? Your lordships, on behalf of learned counsel, Mr. B.R. Tripathi, I may be permitted to appear. Lordships, this is the fourth application of the petitioner. Lordship, the patrolling team of Adaba police on the relevant day of occurrence intercepted 5 motorcycles and seized 199 kg and 100 grams of contraband gaja, kept in 9 numbers of carry bags. 4 of the accused persons fled away from the spot, and the present petitioner was apprehended at the spot, your lordship. I have filed the FIR and depositions copy has already been filed before your lordships, and in the meanwhile, the informant and 3 Caesar witnesses have already been examined.
Out of?
Lordships, that is must be there in the record.
Hey,
No.
how many witnesses are to be examined as per the charge sheet? Yes, 4 witnesses have been examined.
The rejection order they have supplied.
To get that information, how many witnesses are to be examined as per the charge sheet?
Already he has granted interim bail for a period of 7 months.
And your lordships, the informant is himself saying that only from my possession 30.
I have rejected it on merits, I am not going to reopen. I have rejected it on merits. Unless there is a change in circumstance, why should I consider? Yes, one delay in trial, yes, I can consider. But you have to tell me how many witnesses remain to be examined. Only 4 have been examined. How many more are to be examined? Let this matter on 19th September, learned counsel the petitioner shall apprise the court regarding the number of witnesses to be examined as per the charge sheet.
Item 46.
46, my prisoners. On last occasion, also directed to submit a deposition copy.
Hmm.
I already supplied to the Learned State Council. On last, the presentation is custody since 9/11/2021. The case charge sheet was submitted under section 306 and all other allied offences are there. The petitioner is the husband also. This is the second journey of the present petitioner.
Those 2 witnesses examined only in respect of the mother-in-law, as because these 2 witnesses have directly alleges against the mother-in-law. That's why the lordship directed. No relevance with this husband, my lord.
Till date, only 2 witnesses have been examined after direction by your lordship. Out of 27.
Mother-in-law.
The court below is directed to submit a report regarding status of the trial.
Yes, ma'am.
Let this matter on 26th September. This order be communicated to the court below forthwith.
47. Offense is under section 490, 304B, 306, my lord. The petitioner is the husband, my lord. Allegation is owing to further demand of dowry. The in-laws member killed her daughter. On the other hand, my lord, the informant is an arrogant lady and is a psychiatric patient, my lord. She does not obey her in-laws member due to imbalance, mental imbalance, my lord.
Already rejected unmarried. Earlier already rejected.
Rejected.
Unmarried.
Perceive glance, PM report.
I've already rejected it. Anticipatory bail author can consider.
The circumstantial charge sheet is there. Said that
What
is-
what's the
That was the
circumstance?
prior to charge sheet.
Yes. What is the change in the charge sheet?
Subsequently, charge sheet has been submitted. my lord.
What is the change in the charge sheet?
Should be subsequently, FIR revealed 302, 30, FIR is 302, but subsequently charge sheet made 304B and 306. On the LRC have a glance, PM report clearly reveals it's a case of suicide, my lord. FIR and 161 treatment of the FIR clearly contradictory, my lord. LRC have a glance.
No. If you want, I can grant you first or second law.
See, allegation against the main mother-in-law and sister.
No. If you want, I can grant you.
Omnibus allegation, my lord. Ordinary kichi nahi.
Within 1 month of the marriage.
And he has been shown as NBW. He has been shown as an absconder. Absconder charge sheet must have been submitted in the meantime.
ମାସେ ଭିତରେ ବାହାଘର।
Lordship have a glance.
No, don't show me. I have already rejected on merit. How can I?
Secret treatment ଦେଖନ୍ତୁ
No.
କହୁଛି ମୋ ଝିଅ ସୁଇସାଇଡ କରିଛି nothing
See, କହିଲେ କଣ ହେଲା?
single line
So ଆପଣ surrender କରନ୍ତୁ court below. Court below will consider. No anticipatory bail. Court below will consider.
expedited trial.
Considering the nature of accusations and the availability of materials prima facie in support thereof, as also the fact that the prayer for anticipatory bail was rejected by this court earlier, I find no reason to entertain the application again. Stop. The anticipatory bail application therefore stands rejected. Stop. The court below is directed to expedite the trial if there is no other legal impediment. Yes.
Item 48. So anticipatory bail. Expedite trial. Now, in respect of other.
Expedite the trial. Yes. Yes. 48.
No, first it is.
Directed to supply the copy will be supplied.
Copy of what?
Legible copy of the FIR.
FIR and that part where the co-accused person has implicated him, that part he has not supplied. Now he has supplied and he has been implicated on the co-accused statement, my lord. And similar to one Sunil who has been granted bail.
Sunil Garodia alias Sunil.
Yes, co-accused statement.
Well, same order.
Yes, my lord.
Item 49.
ACST Act. Pramod Rai.
Yes.
Pramod Rai, this is 307.
307, 395 is there.
So Pramod Rai जो case था relating to 307 and 395. Senior officer तारा कोटा अच्छी से accept करते हैं. All right.
Clarity payment.
Further, the courts below may consider application of the principle of parity.
Item 50.
That's all it is.
Due to typographical error wrongly mentioned in cost title CP number 15 of 2022.
Your mistake.
Right.
Your mistake. All right. General counsel for the petitioner is permitted to the cost title. The petitioner is permitted to correct the typographical error in the cost title.
Item 51.
I am for the opposite party. To target this case.
No, yeah, modification of one.
4 year case line.
No. On his application, I cannot target the case. Yes, item 51.
Modified pointed to item 15 modified that is mat number 15 of 2020.
Correction order 51.
This modification, my lord. In the earlier order, my lord, your lordship passed granted liberty to appear to virtual mode, my lord. But in the order, my lord, this dictation, your lordship dictation doesn't find place, my lord.
Acha.
Since, my lord, I'm an employee of income tax office.
The following be added after. The following be added in the in paragraph 5. Stop. Further, it shall be open to the petitioner. Petitioner to the opposite party, nahi?
I am opposite.
It shall be open to the opposite party to seek permission of the court to appear through virtual mode. And his personal attendance shall not be insisted upon unless absolutely necessary. Yes. Password.
Password item number 14.
None appears. Disposed of. Chala? Jiba. Chatik. Weekly list I'll take up after recess. Yes, ma'am.
Second appeal concluded.
Didn't.
Appearance.
Yes.
Lordship, item 50, item 51, lordship, I have missed.
Item 51. कॉल पड़ेगा कौन कॉल you are for the weekly list
Supplementary list, your lordship.
item 51 लिखना कौन कॉल है मैं कौन कॉल है there was a modification filed by the opposite party seeking for virtual mode that I've allowed.
Lordship, the copy not sounded, only.
Allowed.
Yeah.
week commencing 23rd. Item 47, lists matter on the week commencing 23rd September.
My lords, item 45 of the weekly list. If my lords may kindly take up next week or some other date.
23rd September. D'accord.
Weekly list item number 19.
Pass over.
So right now 34.
Pass over.
So right now 35.
Pass over.
So right now 37.
Please, ma'am. Here, we are giving a revised set of notes. Earlier, we had given a note.
Who's opposing you, Mr. Mishra?
Mr. Mishra is associated.
Associate is here.
No, I'm not sure on that.
Item 35, Your Lordship. We are appeared through the aviator, Your Lordship.
35 though was passed through.
This is 37.
Yes, sir. I'm sorry.
They are not here.
So you can begin.
Mr. Samir Mishra was appearing. Yesterday he was there.
See, he may come, you may begin.
I'll begin. I'm ready.
So this was recently, the substantial question was reformulated.
Same one, but it was
Reformulated.
not there in the order sheet.
Yes, yes.
So it's against a reversing judgment. And if your lordship would see, the defendant is the appellant. So the suit was for declaration of right title in interest and for recovery of possession in the order. The Learned Trial Court, my lord, dismissed the suit. The lower appellate court decreed the suit in part, declaring the right title in interest of the plaintiff. And since the plaintiff was in possession, that portion was not given to the plaintiff. Now, so far as the questions of law are concerned, on 12/8, my lord has been pleased to formulate 4 questions. If I may place that.
Yes, please.
First one is whether the consolidation ROR under Exhibit 1 could have been relied upon by the learned lower appellate court when the consolidation scheme had been subsequently cancelled under Section 5 of the Consolidation Act, much prior to the final publications under Section 41 of the Consolidation. Now, so far as this question is concerned, it has been answered by 2 judgments, one in 2014 and thereafter in 2021. I'll give those judgments. Then the next question is whether the entry under Exhibit 1 can create any title in favor of the plaintiff in view of the provisions under Section 13(4) of the Consolidation Act, which provides that after cancellation of the consolidation scheme, the entries made under the Consolidation Act shall be deemed to have been made under the Orissa Survey and Settlement Act 1958. So this is interlinked to the first question, also answered by those 2 judgments. Point number 3, whether the learned lower appellate court committed an error apparent on the face of the record by failing to take note of the admission of the plaintiff under Exhibit A, indicating that the defendant number 1 had been in possession over the suit land since 1978 and had constructed a house over the suit land. Question number 4, whether the impugned judgment and decree suffer from serious errors, as learned lower appellate court has not considered Exhibit A by 1, C, D, E, and F in its proper perspective. And the said exhibits indicate that the defendant number 1 was in possession over the suit land since 1978 and had constructed a house over the suit land. So, in this background, my lord may just see what the lower appellate court holds at page.
Just briefly, can you tell me, recapitulate the facts?
My lord, page 32, the facts have been mentioned.
Page 32 of the
lower appellate of the running page of your lordship. Paragraph 3.
Paragraph
Plaintiff's case is there. It is internal page 2 of the judgment of the lower appellate.
Yes.
Ashutosh Bohidar, who died on 16/10/85, was the Lambadar Gontia of village so and so. He was allowed to reclaim the land pertaining to Hamid settlement plot number so and so
After reclamation, he made improvement over the same and remained in possession. Out of the said land, he gifted some portion and sold some portion to different person, and the rest of the land has been recorded in his name in consolidation khata numbers and so measuring 0.13 decimals of suit line more fully described in Schedule A of the play. When the matters were standing thus, defendant number 1 made an application on 24/12/94 before the Tahsildar Sambalpur for mutation, and accordingly the mutation was effected in his name without issuing notice to the heirs of the recorded owner on 16/5/95 in mutation case number so and so. Plaintiff therefore filed mutation appeal number 14 of 95 before SDO sub-collector, and the same was pending. It is submitted in the face of consolidation ROR in favor of Ashutosh Bohidar. The mutation in the name of defendant number 1 is illegal. The order of the mutation authority has cast a cloud on their title, and as such they filed the suit. So this is the basic case of the plaintiff. Now the defendant's case is just below that.
Yes.
Defendant number 1, by denying that Ashutosh Bohidar was the Lombardor Gonti and was allowed to reclaim the suit land, pleaded that there was no consolidation of holdings of land in village so and so, inasmuch as the notification for the consolidation scheme issued under section 3 on 18/11/78 was cancelled by the subsequent notification dated 12/4/91. Hence, consolidation khata number prepared in favor of Ashutosh Bohidar, if any, is invalid. On the other hand, suit schedule A, land covering Hamid settlement plot number 66, was recorded in the name of the government. Now, this portion, my lord, may kindly see.
Yes.
This is something which the lower appellate court doesn't address, this portion. On the other hand, the suit schedule A land covering Hamid settlement so and so was recorded in the name of the government in major settlement against khata number so and so, measuring area of 0.13 acres. The said recording was never challenged by Ashutosh Bohidar or his LRs at any point of time. Subsequently, the Tahsildar Sambalpur granted lease on the plot number so and so in his favor in lease case number 95 of 78 and delivered possession, whereafter he constructed a house there. So these two aspects would be very important. He was paying land revenue, land was separately mutated. In this view of the matter, plaintiffs have no title or possession over the land. The learned civil judge, after framing necessary issues and hearing the parties, held that the defendant number 1 is in possession inasmuch as Tahsildar Sambalpur has granted lease in the name of defendant under lease patta wide exhibit C in 1978. Thereafter, it was also mutated in the name of defendant 1, mutation case number 2195/94. He's constructed a house thereon and paid so and so. The consolidation ROR in favor of the plaintiffs cannot be looked into, as the consolidation scheme at the said place was cancelled by the government. Even if it is looked into, it does not create or extinguish title. Ultimately, it is held that the plaintiffs have no title possession and dismiss the suit. Now, at this juncture, if I may be allowed to show the two judgments, because once the consolidation scheme is cancelled, what will be the result of the orders of the consolidation authority? That's the question formulated. Those would be answered by two judgments. The first one is
Pradeep Kumar Behra.
Pradeep Kumar Behra. 2014 SCC Online Orissa 520. Now, the relevant paragraph would be para 24.
Yes.
The publication of cancellation order under section 5 must be held to have the effect of obliterating and setting at naught all decision of the consolidation authorities with regard to right, title, and interest in land, for the reason that for want of notification under section 3(1) of the Act, the authorities under the Consolidation Act cannot continue to exercise the power and jurisdiction under the Act within the consolidation area. Section 3(1) notification is the starting point that entitle the authorities under the Act to exercise the power and jurisdiction in respect of the area brought under consolidation. Once the Section 3(1) notification is cancelled, the authorities under the Act become disentitled to exercise the power in respect of denotified area. Then in paragraph 25, the court goes on to hold that the matter can be looked on into from another angle, as has been seen earlier. Upon issuance of the notification under 3(1) of the Consolidation Act, the authorities under the Act become entitled to exercise power to decide the question of right, title, and interest in land within the area covered under the said notification, if any. Suit relating to right, title, and interest in respect of such land is pending before the civil court. On the date of such notification, on order being passed to that effect, such suits abate, and thereafter the question of right, title, and interest in respect of the land in question is to be decided by the authorities under the Consolidation Act.
This is the other way around here.
My lords.
This is the other way around. In as much as the consolidation has been cancelled here,
my lords,
isn't it?
Here also it was cancelled.
No, but in this paragraph, probably there's a reference to what would happen when suits are pending when the consolidation operations take place.
My lords.
The notification is issued.
My lords.
That is what he has just for as a way of a clarification. He has. Yes. Then. Yeah, I think it is below. It is said. At the same time, the civil court will also continue to proceed with the suit, which had earlier abated, but revived due to publication of cancellation order under Section 5. So the bottom line is that you want to argue that that consolidation, whatever orders were passed, have got nothing to do with have got no effect on the civil suit.
That is one. And second is, after the thing is cancelled, the orders of the consolidation authorities would be as orders of the authorities under the Orissa Survey Settlement Act. So then the question of title can't be decided by them.
We cannot.
Knows under the Survey Settlement Act, it's only possession, and at best it's a proof of possession. So here this is the position now. The important line here would be the opening line of para 24. The publication of cancellation so and so must be held to have the effect of obliterating and setting at naught all decisions of the consolidation authorities with regard to right, title, and interest. So this was subsequently decided in 2014, but this is the law as we speak today. Now, this has been quoted with approval thereafter. We couldn't get it, whether it's reported or not. It's an unreported judgment delivered by Hon'Ble Justice K.R. Mahapatra.
This is what we have given Satyabhama Sahu. Yes.
We have checked that it is not being carried to the Supreme Bench or the Supreme. But in any case, the same position has been paragraph 11. The same judgment has been approved, para 11. Para 11, in view of the ratio decided in the case of Pradeep Kumar Behra and others Supra, it can be said that after publication of the village under 5(1) of the Act, the consolidation operation is set at naught, and the consolidation authorities have no jurisdiction to thereafter proceed with the matter.
Yes.
After issuance of the notification under 5(1) of the Act, the map ROR under 13(1) Act shall for intents and purposes be deemed to have been published under 12B of the Survey of Settlement Act. In view of the ratio decided in the case of Pradeep Kumar Behra and others, any order passed by the consolidation authorities which culminates in preparation of ROR under section 13(1) of the Act is not open to be challenged under the provisions of the Act. The only remedy available is to assail the ROR by filing a suit or an application under section 15B of the Orissa Survey Settlement Act. So now, what would be crucial here would be the 1978 lease granted in favor of the defendant. That lease has attained finally. That lease order granting the possession of the land and the lease in favor of the defendant, that nobody has challenged. Subsequently, in 1994, the matter went before the mutation authorities for mutating. In the first round, before the first court, we succeeded, the defendant succeeded. The lower appellate court, the mutation appellate court, they relied on the consolidation recording in 1995 and said that no, in view of the consolidation recording, the mutation order is bad. So all that they relied upon was this recording of the consolidation authorities. This was in 1995. That is after cancellation of the consolidation scheme. Because the scheme was cancelled in 1990. So here, so the main point for the defendants to succeed is this, that in 1978, that lease which is granted to you and possession is delivered, that remains unchallenged. And thereafter, a suit is brought about in the year 1995. Just get that right. 1995. So by efflux of time, all the rights of the plaintiff as such were lost. Adverse possession was also pleaded, that has been accepted by the trial court, but lower appellate court has not gone into that issue. Now, if your lordships would see the lower appellate court's findings, how they are not tenable under law. I just read out the two judgments of this honorable court. Now, my lord may see what the lower appellate court holds in this regard. That would be running page 34, paragraph 6. I just read that out earlier. Consolidation ROR in favor of the plaintiff cannot be looked into. This was the conclusion of the trial court. Lower appellate court, my lord may see paragraph 9 at page 35.
Yes.
While considering the respective contentions, I am to observe that it is admitted between the parties that the suit land appertaining to consolidation plot so and so, plaintiffs claim the predecessor in interest, Ashutosh Bohidar, who happened to be the Gontia of the village, was allowed to reclaim the said land along with plot so and so under so and so, and accordingly he reclaimed, improved, and remained in possession. Plaintiffs, in support of their aforesaid plea, relied on the certified copy of the entry of the revenue register of collector of ADM, while exhibit 3, the genuineness of which is not disputed. While he so possessing, consolidation operation started in the village where suit land is situated in the year 1978. As because the assistant consolidation officer refused to record the suit land and other land in favor, he filed appeal number 69 of 81 before the deputy director consolidation. And the deputy director has been pleased to pass orders to record the suit land in his favor, while certified copy of the judgment, exhibit 2. Now, this judgment under exhibit 2 is dated 37/1981. Accordingly, he was issued consolidation ROR parcha under section 34 of the 13(4) of the Consolidation Act. In view of these public documents, it is urged by the learned counsel for the plaintiffs that the appellants, that the finding of the court below that the parties are not in possession is not correct. Now, here the lordship can pause for a moment, and if the lordship can see exhibit 2. Now, all that I want to show, my lords, is exhibit 2 says
Scan any the
exhibit 2 was an order between Ashutosh Bohidar and the government. Other third party people who were in possession, they were not made parties.
Okay. Exhibit 1 is the consolidation parcha. The exhibit is certified copy of judgment passed by the Deputy Director Consolidation.
My lord,
This is what you want me to see?
my lord.
Yes.
Now, so if my lord would see the cause title, it is between Ashutosh Bohidar and the government of Orissa. The appeal, this is the appellate court's order. No other person is impleaded as parties.
Yes.
And what is more important is
And
the
that Bohidar was the Gauntia.
plaintiff, the plaintiff's predecessors.
Yeah.
Now, my lord, may kindly see the relevant portion which I want to show your lordship is page para 7 at page 6.
Of that exhibit 2.
My lord, that is in fact what I wanted to show.
Para 7. Para 7, yes.
The order of the learned ACO is accordingly set aside. The appeal is partly allowed insofar as the disputed line is not to be recorded in the government khata, but in favor of the appellant. It is partly disallowed insofar as notes of occupation in favor of third party is to be retained insofar as plot numbers are to be recorded in favor of the appellant, but in favor of Dhoni Swan. That means the note of possession in favor of third parties was retained. Now, what the lower appellate court records is that the plaintiff is in possession in view of this document. While skipping this portion, that the note of possession in favor of third parties who were not made parties to the case was retained. So this is one error of record which I just wanted to show you all. Because this ultimately would lead to a conclusion that because 78 government grants means we are delivered possession. We produce exhibit A, wherein the plaintiff's predecessor admits that we are in possession. Then there is an order of the consolidation appellate authority recognizing that third parties are in possession. But the lower appellate court, here my lords, records at page number 35, para 9, that in view of these public documents, it is urged by the learned counsel for the plaintiff appellants that the finding of the court below that the plaintiffs are not in possession is not correct. In order to scrutinize this contention, I have perused the judgment and found that the learned lower court has not given importance to the consolidation ROR, Exhibit 1, on the ground that the notification under section so-and-so basing on which consolidation operation was started in 78 has been cancelled by means of subsequent and published so-and-so. So learned trial court didn't give importance to the consolidation ROR because it was cancelled. That is the law laid down by this court. Has been cancelled by so-and-so published on 12/4/91 by the exhibit B. If at all it has any value, it does not create and extinguish the title of the real title holder. The learned counsel appearing for the respondent defendant number 1 also made similar argument in appeal. It is no doubt true that the notification under section 3 of the act basing on which consolidation operation which was started in the village so-and-so was cancelled in 1991 by the state government by virtue of the powers under section 5. But the question is, what is the effect of such cancellation? Section 5(2) of the Act clearly says that where a notification has been cancelled in respect of any area under subsection 1, such area shall cease to be under the consolidation with effect from the date of cancellation. These being the specific words of the statute, the orders of the authorities constituted under the Act deciding the title and possession of the parties prior to the cancellation cannot be null. Now, this finding of the learned lower appellate court is not what is the law laid down subsequently in 2014 and thereafter in 2020.
What about this statutory, that subsection, section 5(2)?
5(2) says that it will cease to be under consolidation. Now, that was interpreted by this court, 2 benches, saying that suppose the cancellation comes about, the orders of the authorities under that act would have the same effect as that under the Survey Settlement Act. Whereas there is no other contrary judgment. In fact, in 2014, since there was a lot of confusion regarding this point, in that single bench order, the Honorable Court also appointed two amicuses to analyze this situation, and after analyzing everything, that has been clearly held. In any event, my lord may kindly see. Thereafter, this is not the only patent illegality. If your lordship goes on, I'll just place that. That where I left, my lords, after that.
Yes.
Cannot be nullified. This is contrary to two orders. Then, my lord may see. In this case, the Deputy Director of Consolidation, and as early as 1981, held that the right title of the plaintiff's predecessor in interest over the disputed plot and ordered that the suit land is to be recorded in his favor along 10 years and long 10 years have. In 1991, the cancellation notification was issued. Pursuant to the said order of the Deputy Director Consolidation, the Consolidation ROR, Exhibit 1 under 13.4 of the Act, was issued in his name. No doubt, the Consolidation ROR Exhibit 1 was published in the year 1992. After cancellation of notification was issued in 1991, but it cannot be said to be, it has no value. It cannot be said the same has no value. This again, my lords, is contrary to the position of law discussed by this. In any event, after cancellation, this ROR could have been published. For better appreciation, I quote section 34. Then this is the lower appellate court's analysis of 13.4. From the above proviso, it is clear that given that even a cancellation notification has been issued under 5.1 of the ROR, prepared on the basis of land register, which was published for all purposes, be deemed to be prepared under the Orissa Survey Settlement Act. The learned civil judge, senior division, has commented that as because there is no evidence that the land register was published and the ROR was prepared on such land register, the ROR cannot be given any importance. This part of the observation of the trial court, according to me, is not palatable. The fact that the plaintiff's predecessor in interest laid objections before the assistant consolidation officer and being aggrieved preferred an appeal would presuppose that the land register was published. It is not the case of the other side, that without publication of the land register at the first instance, the ROR was published and issued. Be that as it may, the ROR issued under 13.4 of the Act not only speaks possession of the plaintiff's predecessor in interest, but also the title. It has to be borne in mind that the preparation of ROR under the Orissa Consolidation of Authorities, so and so, as observed in 2001 OLR versus Commissioner, His Lordship's above decision made such observation basing on the full bench decision, Sundarmani Veva was so and so, where their lordships have held the basic difference between inquiry by the settlement. So then they go into that, and this is that consolidation authorities would decide title. Then, my lord, the court goes on to proceed that if this consolidation ROR is read with entry made in the revenue register, it is clear that he was allowed to reclaim the suit plot as early as 1952, and the plaintiffs continued to remain possession till 1992 when consolidation ROR was issued, and thereafter also when once there was previous entry and later entry in favor of the plaintiff, it cannot be expected that the defendant number 1 entered into possession in 1978 basing on the lease during interim period. No doubt plaintiff's oral evidence regarding possession is weak, but it gets enough strength from the consolidation ROR. In the face of old entry in revenue register and consolidation ROR Exhibit 1, the argument of the learned counsel appearing for the defendant respond number 1 that the plaintiff's predecessor has not reclaimed and he has no title and possession falls to the ground. No doubt the defendant respondent number 1 in support of his argument relied on Exhibit C to say that he was granted Patta by the Tahsildar in the year 1978 and further relied on perusal of the document, No doubt the defendant respondent number 1 in support of his argument relied on exhibit C to say that he was granted Patta by the Tahsildar in the year 1978 and further relied on exhibits D, E to say that the land was mutated in his favor. But let me see how far they would come to his aid. On perusal of the document, it is seen exhibit E is the certified copy of the order of the Tahsildar granting mutation basing on the order of mutation Patta exhibit D was granted in favor of the defendant number 1. These documents exhibit E and D according to me have no force for the reason that the mutation order has been set aside by the appellate authority, namely sub-collector in mutation appeal number so and so. The appellate authority hold in its judgment exhibit 4 that the order of the Tahsildar granting mutation is not proper in view of the findings of the consolidation authority. So here, if your lordship pauses for a moment. Now, again, we are back to square one here. Because in appeal, they succeeded because of this reason that the consolidation authority ROR will prevail. Again, that is contrary to the law laid down by this court. Once there is a cancellation of the consolidation scheme in 1991, thereafter they could not have issued exhibit 1, and in any event, those exhibits will not be of that value. It would go back to survey settlement, and then this order of the appellate authority should not have stood on the way of the lower appellate. So at the same, that means I would have to repeat the same thing. He shouldn't have gone by this appellate order.
The point is taken. Yes. Any other point?
Just there are 2-3 things I wanted to show, my lord.
Yes.
One is the lower appellate court has given a lot of emphasis on the consolidation authorities order. The other issues which were dealt by the trial court that have not been dealt with by the lower appellate. There were issues regarding who is in possession, regarding the entries of 78, then other documents which we had produced. So there one judgment of the Honorable Supreme Court, my lord knows, 2001, Santosh Hadari versus Purushottam Tiwari, paragraph 15, where they say, my lord knows that when you are concurring with the judgment of the trial court, you can just generally concur and say that everything is in order. But when you are reversing, you have to deal with each of the individual issues. So lordship wants, I'll show that paragraph.
Yeah.
So while reversing, he should have gone into each of the issues dealt by the trial court. But here, only on the basis of this consolidation authority, it was recited. So that is another point which I just wanted to show. Now, certain interesting findings, my lord, may see how this judgment cannot be accepted. At page 40.
No, you have to say the internal page or the paragraph.
Internal page 10.
Yes.
Paragraph 10. That begins from the MS suit so and so. Defendant number 1 should have adduced evidence showing correlation of the plots. In the absence of such evidence, the alleged lease Patta cannot be tagged with the suit land. This is one aspect of the matter. The other aspect is, if at all suit consolidation plot corresponds to so and so possession, it is not known as to why he did not make any objection before the ACO claiming the suit land. Now this, my lords, is a patent illegality, my lords. How will I object when I was not a party to that case? There's no, and in that appeal, if he doesn't implead me as a party, how will I go and object? So these findings are, my lords, without any basis. For having not made any claim, I think the consolidation ROR in favor of the plaintiff supersedes the alleged lease Pattas in favor of defendant number 1. Now, if your lordship goes by the dates also, our lease granted by the government is dated of the year 78, which nobody has challenged. And their consolidation ROR, my lords, is much after that, 81. Even if that order is seen, first of all, we are not parties there. And that order records our possession. So ultimately, if your lordships may not agree with me on some of the points, but then this is something which would stare at the plaintiffs. We are in possession since 78. You come in a suit in 1995. And this issue has not been analyzed by anyone.
That's all?
No, para 11, my lords. Again, they go by the order of the appellate authority. Mutation appellate authority, para 11. That is also because the appellate authority went by that consultation recording only, nothing else. Now, the first authority in the mutation court, it took note of the lease granted in my favor in 78. So that has not been discussed at all by the lower appellate court. Another interesting paragraph to show how this judgment is patently illegal would be para 13, page 41.
Yes.
In view of my aforesaid discussion, the finding of the learned lower court that the plaintiff has no title and possession are not sustainable. Alternative plea raised by the defendant number 1 is that otherwise he acquired title to the same by adverse possession. In considering this plea, I should say that I have already held plaintiffs are in possession, but not defendant number 1. Assuming that the defendant number 1, this line, my lord, may kindly see. Assuming that defendant number 1 is in possession, his case is that he is a lessee under the government, and if that be so, he cannot claim better right title therein. Even otherwise, the claim to title by adverse possession, the party who claims is to establish so and so. Without case, defendant number 1 so and so, 78 onwards, but perusal of evidence, it is seen that plaintiffs have not allowed the defendant to remain in peaceful possession if any. The predecessor in interest claims so and so. No, I don't know how far these kind of findings would be acceptable. And the admission of the plaintiff is recorded in Exhibit A. Sharat Chandra Bhagidar. That document, if my lord can just see, regarding our possession.
That memorandum of inquiry.
My lord. Persons present at the time of inquiry. The plaintiff, Sharat Chandra Bhagidar, was present. And the specific admission of is, I'm just placing that. The lordship may see that entire, because this is also a question of law formulated that the lower appellate court ignored this. Govardhan Khamari, son of Sadhar Khamari, is a displaced person of Hirakud Dam project so and so. Merged area, the displaced land so and so under so and so was leased out to Govardhan Khamari by the government in the year 1978. The witnesses adduce oral evidence that Govardhan Khamari is in physical possession of acre 13 decimal of land since the date of leasing out and lying by lease case number so and so. He has constructed a Khaprali Kacha house over the said land and is occupying the same. The objector, next paragraph below that, important. The objector, Sharat Chandra Bhagidar, admits that the Khaprali house standing on the land at present was constructed by Govardhan Khamari. The objector states that the disputed land was also leased out to Astos Bhagidar, ex-Gontia of so and so, by the Deputy Commissioner of in the year 1951 to reclaim the cultivation. So in view of this, my lords, at least possession remained with us from 78 onwards, and then they come in 1995. There was an alternative for whatever it's worth, my lord. There was a plea for recovery of possession also in the plea. The lower appellate court, even if your lordship sees the opening lines of the judgment, that prayer itself is not mentioned. That would also probably show some amount of non-application of mine. Opening lines, it's only title confirmation of possession and permanent injunction. That according to me, my lords, my most humble submission, that this is an aspect which the court shouldn't have ignored. Great.
Yes, Mr. Mishra.
My lord, if your lordship pardons me, I'll reply tomorrow. My
I will, no, why tomorrow? We'll keep it to some other day. I'll keep it as part heard. No, you.
ना समाधान रहिले हब म कहिले काले आपण सुनुचन सुनदेबे
I normally start a matter and I keep it as part heard to stagger my judgments accordingly.
Ma'am, I will know.
If I complete it tomorrow, I'll have to deliver
Because
that.
after hearing my learned friend, your lordship was pleased to formulate fresh substance.
Reformulate. Though whatever was framed earlier, खाली 1, 2, 3, 4 बोले खाई गला ताको reformulate.
चारटा रे होची कि नहीं सेटिक तो टेस्ट हवा किछ नहीं अब मु खाली मो my friend has noted whatever my learned friend has argued मुटिके सेटा जेतो अन्य गोटे पार्ट है
No,
totally
we'll take it up. I'm just finding out who the noche part heard देखलो. Interroge तो week commencing 23rd रो करियो हैला. So week commencing heard in part less this matter in the week commencing 23rd September. It will come in the top of the list.
Yes, my lord.
I take up all part heard matters. Well, this is my view.
I understand.
This is my
सेटा सरी जाए कि तापरे अन्यडा का रेगुलर है grateful man.
At least that way some matters are and I am able to
It should be disposed of that way.
Rightly, wrongly, whatever.
The other case I remember my lord
We'll take
Mr.
back the
Vidyadhar Mishra and my lord Mr. Bagh were arguing. I think that has been closed, right?
No, 10th को रहला है. 10th को रहला है only for a brief reply by Mr. Vidyadhar Mishra.
But Mr. Ross and Mr. Rao and Mr. Rao's matter has been closed. That section 15 and 16.
I don't remember anything.
I don't want to.
The court has become functus officio.
The last part of it, my lord, I don't want to remind.
The court has become functus officio.
My
Yes.
These judgments and all will take it back.
I think it will be better if you file your note after conclusion of argument. Maybe you want to factor in something that he has said. Though in one of these judgments, I have made some markings. Whatever you refer to, I have highlighted it. So it will be better if you give it at the end of the argument.
I think these are all referred to in the submission that has been filed today.
Yes.
These are all
We have given a copy.
So after hearing Mr. Mishra, you may again like to revise your note. But
yes. Judgment reference
address.
Grateful to you.
49. Yeah, भीतर सब सही है. तो Friday bro ये. 49.
now 54 is a kali ki apnar
Yeah, जोड़ा काली की रोची से तो डॉक्टर लेने से. Item 49. Yes.
I am for the respondent or the subsequently the appellant is not appearing.
Will dismiss it over there. काली dismiss किंतु काली हो. And weekly list was ना. So I will pass that order that every day it was called out, nobody had appeared. So I will grant him one more opportunity. 2018 second appeal था. Dismiss करेगा तो.
लिखाई लास्ट लास्ट 3 थर से आए.
देखिए. All right. Next.
So that's not 50. I'm for the respondent.
Who's for the?
Son order is operating against me.
Who's the appellant? Last time also there was no appearance.
Continuously I am appearing.
No, but don't worry, say same order. But tomorrow it will be passed. You don't have to appear. Mr. Bishal is there. Oh, non-appears with the appellants on repeated calls. So I'll have to, but this order cannot be passed today. Since being in the weekly list. Correct, रखे हो, है ना?
So right now 52.
52. से कोई तरह की काली हो बोले? 52.
Praying for an adjournment.
Adjournment?
Yes, Your Lordship. Kindly this matter may be taken up next week, Your Lordship.
Very. Next one. How one? We commencing 23rd September.
Interim order is there, Your Lordship.
Interim order to continue.
Obliged to know.
After item number 56.
56, yes, ready?
And for the applicant.
Yes, who's for the?
And Mr. Amit Bose is also coming.
Ready, you can begin.
Yeah.
If you're ready, you can begin. Yes.
Pardon. So the item 37, I was, there was an interim order, my lord, that.
Item 37,
My lord.
which Mr. Gautam Mishra was arguing.
My lord.
All right, interim order to continue. Item 37. Let us begin.
Obliged.
Introduction in front of you.
There are two appeals.
Two appeals. Oh, yes.
Both the appeals.
You have filed both.
Appellant is the.
Is it against a common judgment?
One is confirmed and obliged. There are two appeals. One is a common judgment. But there are two appeals.
Who are you? You are the plaintiff.
I am the defendant number one. Defendant number one is the purchaser from defendant number two. The plaintiff has instrumented the issues seeking preemption of certain land which has been described under Schedule 4 of the
Yes.
Schedule 4 is a part of property described under Schedule 4.
One question.
Schedule A is the junior.
Yes.
The plaintiff in the suit has specifically stated that possible land which has been sold away by the defendant number 2 in favor of the defendant number 1 is the plaintiff.
Just a moment. Mr. Satpathy, you are appearing for 4, 5 and 6.
In 167, I am appealing for the one, respondent number one.
Mr. Bose is appearing for respondent number 1. Who is appearing for 4, 5 and 6?
Sir, 5.
Oh, you are appearing.
I am for 3 and 5. 3 and 5.
4 and 5 K. 4 and 6 K.
4. Sir, read number है यही थी वो तो डेढ़ पार्टी करते वो तो तापर read number है यही थी वो
So I have said 4, 5 and 6. So everybody is represented now. All right. Please continue.
It is the respondent number 1. He is in fact contesting. Mr. Bose will.
No, he will argue. He will argue.
Yes.
Today I am not closing it.
Yes, no.
Take note. So that you can appraise your senior accordingly.
Now, that's happened. The plaintiff has specifically billed that the property sold under Schedule 4 of the claim belongs to the joint family. And the defendant number 2 has no right of authority to alienate the said property are covered with the residential vision. This is the allegation for which he has sought for the relief of preemption and also the permanent injunction against all the defendants. The defendant number 1, which filed his written statement, internally stated that the defendant number 1 is not a stranger. The property has been earlier put into partition, and Section 21 of the Hindu Succession Act has no application to the present case. This is also the prime consideration in the present appeals. The three points are the prime consideration. In order to establish that there has been previous partition between the recorded tenants, there are certain sale deeds which have been marked as exhibits, wherein the plaintiff and the other co-sharers have alienated portions of lands, saying that we have got this property by virtue of the family partition. And there are also a genealogy which has been described by the defendant number 1, saying that he is not an impostor or stranger to the family of the plaintiff, and he is the nephew of the defendant number 2. That has been specifically pleaded in the written statement. And during the examination, the defendant number 1, who was examined as widow number 1, has stated all the entire thing at paragraph 2 of the statement, examination in chief. From such statement, there has been absolutely no fruitful prosecution to demolish such status of the defendant number 1. On the other hand, it is also pleaded that the plaintiff has stated in the claim a part genealogy. A full genealogy has not been given.
And full genealogy has been described in the evidence in chief of the detail number 1, saying that he is not a stranger to the family, but he is nobody but the nephew of the defendant.
So let us go to the genealogy first in order to understand the relationship.
The plain establishes a part genealogy.
No, but what according to you is the right genealogy? Where is it mentioned?
I have mentioned in the paragraph 2 of my evidence in chief.
Evidence in chief. Are you'll say it also? 56. Okay. I'll say is that.
In order to have a clear appreciation of the genealogy, I would like to find a written note of argument stating the relationship of the defendant number 1 with the plaintiffs and the seller of the defendant number.
There is a genealogy mentioned in the decree also.
I will
No, I'm finding that there is a genealogy attached to the decree.
genealogy of no, a part of genealogy is attached with the plaint. Plaint A schedule is the part genealogy.
Okay.
Page 91 में appeal में question page 91 में genealogy.
It's a part genealogy. I'm submitting it is a part genealogy given at the plaint.
Okay. Okay.
Now, if it will be seen that the paragraph 2 of the evidence of the detail number 1, complete genealogy will be established. In the written statement.
PW1.
DW1.
DW1.
Cost schedule has been. It is stated that cost schedule is not fully correct. The correct genealogy has been described in the.
In which paragraph?
Paragraph 2 of DW number 1.
ଗାର କାଟି ନ ଦେଖିଲେ ଗୋଟେ ପଢିଲେ ବୁଝିବ ଭାରି difficult. ସେ ଗୋଟେ paragraph form ରେ କହିଛନ୍ତି.
Now, after argument, the hearing of argument, the learned trial court declared that decree of permanent injunction is available to the plaintiff, but declined the relief of bench. So, 2 appeals have been made. One is by me and another by the plaintiffs. Plaintiffs challenge the decree that's stating that both the reliefs are available to them. Instead of that, the court has granted the relief of permanent injunction only and refused the other relief. And myself, the defendant, has also challenged the relief of perpetual injunction. Both the appeals have been heard analogously and a common judgment and decree has been passed, wherein the London appellate court, first appellate court, has granted the relief to the plaintiff. Plaintiff's appeal has been declared. My appeal has been dismissed. So, 2 appeals have been referred by me. The London trial court has categorically held that relief under section 22 is not available to the plaintiffs in the circumstances that prior to sale of the property described under Schedule 4, such a offer of such a sale has been made to the plaintiffs who have declined such offer, for which at the subsequent time the defendant number 2 has alienated the property in market. So, the relief claimed under section 22 is not available. And first appeal court has held that since both the courts have held that I am a stranger to the family of the plaintiffs as well as the defendant of my seller. The London first appellate court has held that the relief under section 22 is available to the plaintiff since the defendant number 1 is a stranger and the property consists of structures of the joint family dwelling of such and such, and decreed the relief. Okay. My respective submission, my lord, would be that whether the relief under section 22 is available to a party after a concluded transfer. Section 22 speaks specifically that if a person propose to sell the property in favor of others, the class 1 heirs will be entitled to the relief. Here in this case, there has been already concluded transfer. I mean to say that the defendant number 2, prior to the institution of the suit, has already alienated the property in favor of the defendant number 1, and defendant number 1 has constructed a road to the property and has obtained permission from the local authority for construction of the building. And also, it has been specifically stated that no such part of the structure of the plaintiff is on the land which has been purchased by him, and it is not at all a dwelling house, portion of the dwelling house, and no part of any temple is there. There is a vacant land, and also the RO established the position. It is recorded as verbally, and further description of the bylaw. No existence of a dwelling house is recorded, or any other temple or any structure has been recorded. So my submission would be that since there has been a concluded transfer and the property doesn't belong to any portion of the dwelling house or any other structure or temple as has been pleaded in the claim, section 22 has absolutely no advantage. And that apart from my pleading and evidence, as I available at the case report, it would be amply established that the defendant number 1 is nobody, is the nephew of the defendant number 2. In view of the specific pleading set forth at the written statement, so also the evidence are laid by him, which has gone no demolition of the proceedings. So, in view of the position that I am the member of the family of the plaintiff and defendant number 2, such a relief of perpetual injunction will not be attracted. And the other submission regarding partition of the joint family property is amply available at the exhibits. Those are exhibits. Exhibits D, T, U, V, W are all cell lists, wherein the plaintiff and the other parties have alienated some portions of the present suit land and other lands in favor of the strangers. Upon specific admission that they have bought.
So they were dealing with those properties.
They have bought the specific property by way of their family partition. So, since those exhibits have been completely ignored by the one report below, which have a time effect to the.
No, has he completely ignored it, or has he to consider it and rejected it?
The London and the lower appeal court, after going through the contents, have held. No,
there is not proof of prior partition.
There has been no partition. There has been no partition. And still, the property given under the schedule Go is a joint policy. Held that it is a joint policy. Held that the defendant number 1 is a stranger to the family.
How has the court below justified such finding?
I say it is a clear admission of the plaintiff that he has bought the property by virtue of.
How has it been dealt with by the first appellate court? On what ground has he said that?
So there was a specific person saying that by virtue of family partition, I have got it.
That is right, but how has the High Court, first appellate court, dealt with that?
In the finding, it held.
Let us see that finding. Let us see that finding.
Those are ignored. Lord and first appellate court, page 18 of the judgment, paragraph 10. Yes, some simply.
Yes.
Yes, simply concord with the findings of the London Trial Court. I have carefully considered the rival submissions of the parties, gone through the grounds raised in the respective memorandum of appeal filed by the plaintiffs and defendant number one vis-a-vis the impugned judgment and decree passed by the London Trial Court, the pleadings of the parties and the evidence on record. On careful perusal of the impugned judgment and decree, I find that the London Trial Court, on scrutiny of the evidence on record, found that the property described in law schedule of the plaintiff was the joint family property of the plaintiffs and defendant number 2 to 5, and there was no partition by Wilson.
Yes.
And at paragraph 12, relief of section 22 has been dealt with. The legality of the findings of the London Trial Court are to be examined in the aforesaid undisputed factual background. The plaintiff's main grievance in the appeal against the impugned judgment and decree is refusal of the London Trial Court to their prayer for exercising the right of preemption under section 22 of the Hindu Succession Act 1956, which was objected by the defendant number 1 and 2 on the plea that there was an amicable family partition among the parties and defendant number 2 to 5 in respect of the joint family property. And while the defendant number 2 was possessing or share as per amicable partition, alienated the same to the defendant number 1. The other ground on which they are also deferred the claim of the plaintiff for preemption that the defendant number 2 offered the plaintiff and defendant number 3 to 5 in presence of our caretaker Rajendranath Manti to purchase the suit schedule property, which they refused to purchase, for which the defendant number 2 sold the property to the defendant number 1 to meet her legal necessity. The defendant number 1 also in his written statement claimed that he is not a stranger to the plaintiff and defendant number 2 to 5, but a member of their family, which they have admitted in different registered sale deeds. Before scanning the evidence on record to examine the correctness of the impugned judgment and decree, refusing prayer of the plaintiff for exercising the right of the preemption, it is appropriate to take note of the relevant provision of section 22 of the Hindu Succession Act, which is as follows. It is quoted, section 22, preferential right to acquire property in certain cases. In clause 1, the word proposes to transfer, I am highlighting the words proposing to transfer, and my respectful submission would be that say it is not a proposal of transfer, but it is a concluded transfer. So in case of concluded transfer, section 22 has no application. And also subsequently, the London First Appellate Court has cited some decisions, and in view of such decisions held that section 22 is available and decreed his application. So now, resultantly, the position became thus that the plaintiff got all the claims as has been claimed for by the plaintiff, both the prayer for preemption and purposeful injunction. It is now made available to them by the judgment and decree made by the London court. So, upon such predicament, all the documents and the secondary evidence as is found regarding genealogy, I feel that I am not a stranger and I have purchased a specific property of the defendant number 2, which he has got by virtue of family partition, and the relief as has been granted to him, granted to the plaintiffs under section 22 of the Hindu Succession Act, is not at all available to them, and report the both the appeals.
We'll give a reply.
Sorry?
Who will reply?
No, it is Mr. Bose really needs to, because he is the plaintiff. We are all other defendants in this.
You are the purchasers.
No, no, we're supporting defendants, family members, but they were supporting the plaintiff. They have filed their written statement or even the present defendant numbers 3 and 5, they did not contest the suit also. So it is Mr. Bose who is to.
Third in part, is this matter in the week commencing 23rd? 23rd? No? In detail, no? 23rd. So, thank you. Sorry. এগারোটা যে কালিতে এগারোটা তো নেই গোটাকে গোটাকে বেশি করে বলো না